code is 317615. Call to order. Paige Rassid is present. Dan Ferrero's present. Carl Walton's present. I'm present. Jennifer Roy's present. Staff liaison. Town attorney Carl Landolina's present. And is Bill Shapiro present? Bill, if you're here, you can unmute yourself.
On the phone, you can unmute yourself with *6, I believe.
Good to know. Thanks, Dave. And Lucas Cherry, is Lucas here?
Doesn't appear as though.
Okay, so we're going to say Bill is not here, and neither is Lucas. Okay. So, moving right along, we're going to start off with a public hearing for application number 20-009, Amy Eastman, 40 Halley Lane, Summers, pursuant to Article 12, Earth Removal and Filling, Section 214-70, assurance, issuance and renewal. It's an issuance and renewal of a special use permit application seeking a special use permit to unearth, excavate, remove, and fill of approximately 9,650 cubic yards and the removal of that material to an abutting conjoining property parcel at 42 Halley Lane. So we're going to open this public hearing up. I'm sure the applicant, Attorney Dwight Merriam's there to address.
Yes, he is. I'll give him a...
So I'm just going to go through a couple things we have to keep mind of while we have a public hearing. When you speak, you must state your name and address, and every time you speak, you must state your name and address during the public hearing. Address initially, but your name every time you speak. And in order to speak, you need to unmute yourself. So we're going to let the applicant come up, or you'll audio hear the applicant's application. If you're ready, Attorney Merriam.
Mm-hmm.
Thank you. Good evening. My name is Dwight Merriam. I'm a lawyer with offices at 80 Latimer Lane in Simsbury, Connecticut. And I represent Amy Eastman, the applicant for the special use permit before you this evening. She's applying to excavate approximately 9,650 cubic yards of rock on the lot where her home is located, 40 Halley Lane. Amy Eastman has lived there for 15 years with her husband and now 10 children. They seek to improve their landscaping with more play and recreational area for their family. As has been described to me, this is not only their home, but they also consider it their vacation home in that sense. She is not applying to remove any material from the site, nor to bring in any material. This is just to excavate the rock and to keep the material on site. It is proposed that approximately 1,600 cubic yards closest to the house will be excavated with a technique that involves drilling holes in the rock 3 feet apart on 4 feet deep, and then placing a hydraulic device into the hole which cracks the rock. Now, I believe that the zoning enforcement officer and the town attorney both had an opportunity to observe that work, and maybe later if they're asked, they can reflect on that. I didn't discuss with them beforehand this evening. I haven't heard it, but I believe that they were in the area and observed that activity going on, and I believe that the report to me is that it could not be heard off-site. It's just drilling and cracking of the rock. The balance of the 9,650 cubic yards is proposed to be removed with blasting. As you know, there has been jackhammering on the site. which does have its noise impacts, and certainly blasting does too. But the significant advantage of blasting, which is very significant, is that it's intermittent, it's not continuous, as the jackhammering was, and it is over very quickly. If blasting is not used, the drilling and hydraulic fracturing technique and/or jackhammering will take at least twice and maybe 3 times longer than blasting. If blasting and the drilling is used together, the whole operation can be done within 30 days. If not, it would go on longer. With me tonight is John Parks, over here to my right, who's represented Amy Eastman since the outset of these continuing controversy, and Jay Ussery, the surveyor from J.R. Russo and Associates, who's the project manager. Jay will be testifying on the details of the special use permit application and the provisions of your regulations. We'll make a presentation that doesn't take too long. I only have 4 or 5 minutes worth up here up front, with the hope that we'll be able to close the hearing, deliberate, and that you'll be able to vote this evening if at all possible. Approval would allow the excavation work to proceed immediately, and it can be done, as I said, within a month or less. This special permit is the first step in a 4-part process to resolve with finality the issues that have arisen regarding the work at 40 and 42 Halley Lane. I'm going to tell you about these next 3 steps so you can put in context what we're asking for tonight and what Amy Eastman is seeking for you in terms of deliberation and vote this evening. These other 3 steps, what's going on in them is not relevant to tonight's proceedings in terms of evidence, and we won't put on any evidence about them. But let me just tell you what they are so you know how this particular application fits in with the larger approach to getting this done once and for all. In fact, possibly within the next month. It may seem a little complicated to do 4 things at once, but it really is simple and straightforward. And the advantage of it from the town's perspective and the neighbor's perspective is it allows us to tailor the approvals to the minimum necessary to complete the work that needs to be done. It leaves virtually 7/8, nearly all but 1/8 of 42 Halley Lane in the A zone, and it limits further work in what is now 42 Halley Lane to just 5 acres of positioning the excavated material from 40. Importantly, you as the zoning commission have full control over this process through the SUP tonight and through a later rezoning that I'll describe briefly, and a second SUP as I'll also describe. So here are the next 3 steps after tonight. First, Amy Eastman has submitted to the Planning Commission a boundary line adjustment between 40 and 42 Halley Lane, which will expand 40 Halley Lane by about 9 acres into 42. It's only 9 acres because Jay and I discussed it and wanted to square off where the boundary change was. We don't need all 9 acres, we need about 5 acres of that to complete the work to be done, but it is a 9-acre lot line boundary adjustment. It'll go to the Planning Commission for its review, but no new lots are created, and so it's exempt from subdivision approval. Second, with this newly configured 40 Halley Lane, where the Eastman residence is located, an additional 9 acres, we're going to propose to rezone about 5 acres of that, just 5 acres immediately adjacent to the Eastman's family lot. And that 5 acres will take the material that will be excavated on 40 Halley Lane with the SUP that we hope will be considered and granted tonight. That application for the rezoning is being received by the Zoning Commission tonight by you and referred to the Planning Commission, which meets, I think, on the 18th, is it? And anyway, coming up in the next couple of weeks, and then coming back to you later. So you'll have another point of discussion and discretion with regard to the rezoning of that 5 acres. And what it does is allow, as I said, this excavated material from 40 Halley Lane, which could stay there, but allows it to be moved over to that immediate 5-acre piece on 42, which allows then the finishing of the lawn area for the rear lawn of the Eastman home. And finally, upon approval of these four proposals, the special use permit to excavate 40 Halley Lane, which is before you this evening, the boundary line adjustment, the rezoning of the 5+ acres, and the second special use permit to allow the relocation of the rock, this will be done. It'll be done with finality, with the exception of actually completing the physical work on the site. So with that, I'd ask Jay Ussery to, with reference to the site plan first, and then with regard to your regulations, to brief you on what the proposal is for this SUP and its compliance with your regulations. Jay?
Jen, I'm assuming the commissioners have plans with them that they're looking at?
They do have plans, but you probably want to come here, like close to the
That's what I'm asking. Where would you like?
microphone, for the microphone.
So,
Yes, they, whatever was sent with the application they have.
This is Jill Conklin speaking. We did get an email of the plans, however, they're emails. They're very small and very hard to read, so, yeah, so it's just putting that out there.
You know what, maybe I can, do you want me to turn my computer?
This is Jill Conklin. Again, maybe the applicant could make enough copies for the commission.
For after tonight.
Yes.
good evening. For the record, J. Ussery, J.R. Russo and Associates here representing Amy Eastman with regard to this special use permit application. As Attorney Merriam described to you, this is essentially a 4-part process, and I've got an overview plan here that shows the entire property, which is 40 and 42, to just kind of give you an overall location as to where we are, and then I'm going to get specific in terms of this application itself, which is really the house lot, which is 40 Halley. So if we're looking at this plan that I have here in front of you, if we look at the lower portion of the sheet, we have the cul-de-sac at Halley Lane located there, and the driveway up to the Eastman residence winds its way up the hill, and the house is located here. Off to the east, we have Mountain Road, which is located over here. And then if we look at the key map, you can see over here, Long Hill Drive, and the cul-de-sac at the end of Long Hill is over here. And then if we go further east, we've got Turnpike Road, Hickory Hill Drive, and then Amy Lane that comes across to Long Hill from Halley. So overall, the area that we're looking at with regard to the 4-step process essentially is this area right here. But tonight, the application that you have before you to consider really is just the application at number 40, and to get more specific, we're going to look at a larger scale plan at 40 scale, which is what's required in your special use permit regulations, and also what's required in your excavation section of your regulation. The area that we're really talking about here is this area of excavation that's cross-hatched right here. And that particular area is about 1/3 of an acre. It's not very big. And there's about, as Dwight had said, I think a little over 9,000 yards in total that it needs to be removed from this area and hopefully eventually be moved to the back in that other area that I described to you. So what this plan shows is existing and proposed contours, which is required in your regulations. Shows the area of excavation. Existing contours range from about 600 up to about 620 up at the top of the rock area, which is right in here. So in total, there's about 18 to 20 foot of excavation at the most extent or deepest point, I guess we might say. And then it grades back up and comes back in over on the easterly side. Right now, the existing contours, again, this is kind of the top of the little hill here, so we've got some grade off in this direction, some grade off in that direction. At the end of the day, it really doesn't change that much. The top of the hill is here. There'll be a little more shedding onto the Eastman property and maybe a little bit less going this way towards Schlafstein's property off to the east. There is excavation, which is closer than 100 feet on the easterly side, and that's required as a buffer in your regulations. However, the Eastmans have permission from the Schlafsteins to go closer, in fact, to go up to 10 feet, I believe it is, and we have documentation of that. If it's necessary, we can supply that to the commission. In fact, you may already have it, I'm not sure, but we do have that. So again, area of excavation shown here, about 1/3 of an acre in total in size. So there's a number of things in your checklist, I guess, that we need to talk about with regard to this application in terms of looking at soil and erosion control and wetlands and runoff and how we're going to protect neighbors' properties and so forth in terms of soil and erosion controls again and wetlands, and we need to look at water wells, and a lot of these things have been talked about before at earlier meetings, and I'm probably going to be a little redundant here when I get into this, but I'll try to make it as briefly as I can. But anyway, we've already talked about the location of the area to be excavated, and it's, again, the crosshatched area here. It's about 1/3 of an acre. This material hopefully will be moved to the back of the property once this entire process has gone through your approval process. Topsoil depths here vary from 0 on the exposed ledge to anywhere from probably 4 inches or maybe a little more, 5 inches in the wooded areas. There's not really very much topsoil. Depth to water table. Now that's something that's been talked about probably going back to the fall when this project started, and when I got involved in the project, let me rephrase that. So I'm going to go back again to the overall map here because there's a little more information here. And Steve Jacobs, I think, put together a memo that he sent to staff, which you probably all saw a copy of. And in that memo, there was some directive that came out from DEEP with regard to water wells and excavations and rock and so on and so forth. And really what that directive said was, if you have water wells that are within 500 feet of a proposed excavation or blasting operation, you need to consider certain things. So Steve sent that out to staff. The Eastmans got it, and they hired OTO, O'Reilly, Talbot, and Oaken, and they did a study on the water. They did a study on the material that's there. They took a look at the directive. But before I even go there, one of the things that I want to say is, it talks about wells within 500 feet. So we were able to get through town staff locations of most of the wells in the area for the surrounding neighbors. When the homes were built, the wells are required to be tested, obviously, to get approval from the health department so they can use them, and they also give you as-built information for the location. So we were able to put together, we think fairly accurately, the location. There's a well located over here. The Eastman's well is here. There's a well here, here, and here. And the excavation area currently is limited to right here. The only well that's within 500 feet in that area is the well on the Eastman's property. None of the others are. Now that said, these wells are close. Maybe 500, maybe 510, maybe a... You're way out here.
No, I'm down there. I'm not Amy.
Okay, well, you can ask a question later. I'm not sure who you are. So at any rate, these are the ones that were close that we have. And as I said, other than the Eastmans, nobody else is within 500 feet. But some of them are close. So they had a study done by O'Reilly, Talbot, and Oaken, which is here, and I can submit a copy, although I think you probably already have it.
Oh, but
We will
considering...
submit one tonight
Yep,
for the record.
right.
And essentially, they looked at a number of things. They looked at groundwater, they looked at arsenic releases, they looked at radon. It's hard to hold this and talk. I'm pages. And they looked at perchlorates, which sometimes are used in blasting. They looked at vibrations in terms of wells and building structures. And essentially the conclusion was, by Mr. Talbot, that he didn't have any concern with any of these items. Because of the distance, the type of the rock that they have, which is highly fractured, so in other words, it's not going to be difficult to break it apart. Low charges, not real heavy blasting, I guess you might say. And he didn't have any concern with regard to these things. In your regulations, you talk about depth of water table, and it says they want to know what the depth of water table is before the work and after the work. Well, based on Mr. Oken's report, or Mr. Talbot's report, they don't expect to see any change in the water table. So we were able to get locations, as I said, of the wells, of the ones closest to the neighbors. And we were able to get elevations off the GIS. So the finished grade elevation up here when we're done is about 600. The neighbors' wells ground elevations are lower than that by 64 feet, 82 feet, 82 feet, and 33 feet. So they're substantially lower than where we are at our 600 elevation. But we were also able to get the information on the Eastman's well. Their well's 460 feet deep. It's very deep. The water table here is extremely deep. So we don't expect any issue with regard to changes in water table or any effect on anybody's water wells with regard to the operation that's taking place here. And so we have one here for the record. We submit a copy of this report, and it relates to, again, the directive that Steve Jacobs submitted to the zoning office from DEEP, which I know you have a copy of, and Steve has commented on that report as well. So that said, let me walk through a few more of the checklist items that is in your regulations, just to talk about them briefly. And I'm sorry if I need to bore you with some of this stuff, because I'm sure you would consider some of it boring.
Jay, can you, if you're comfortable with moving that or talk louder, just to make sure that they can hear you on the Zoom. Thank you.
So we talked about the area of where we are in terms of Amy Lane. Off to the east, we have Mountain, and off to the west, Long Hill, and then further west we get to Turnpike. So we know where we're working. We're at 40 Alley Lane. In terms of timing of this particular project, as Dwight had explained, it's a 4-step process. Assuming everything goes as planned, completion would be before the end of this year. And when we say completion, we're talking about final grading, topsoiling, and probably some seeding. The topsoil we talked about at various locations. There's very little topsoil here. A lot of it has none on the open, or I should say bare ledge. Water table before and after, we don't expect any change in the water table. The water table is extremely deep, hundreds of feet below where we're working. Proposed truck routes is something we need to tell you about. However, I will say that there's nothing leaving the site, so there is no truck traffic leaving here. The equipment that they're going to use to do this is already there, so we really don't expect any truck traffic. Trucks would navigate around essentially the center of the property when work is going on, moving material from one side to the other, and they would be more than 100 feet from any property lines in doing this work. Existing and proposed drainage, I talked about a little bit. We've got a little high spot there. Once this grading is complete, there'll be essentially no change in drainage patterns or runoff on the site.
It's got the audio on the video here.
In terms of runoff, soil erosion, and sedimentation controls, let me go back here to the detailed plan. And we are showing soil and erosion and sedimentation controls here. Most of it is already in place. There's a little more that needs to be added over here. There's details here on how it has to be installed. But to be honest, I've been up there a few times now. We're basically working with rock, and there's very little soil, if any, being moved around, and there really isn't any erosion because, quite frankly, rock doesn't really erode. So I don't really see that as an issue. The plan shows at 40 scale contours, 5-foot intervals, existing and proposed. We are not proposing any structures, so there are none shown to be built. The only thing that's there is the existing structures we're showing surrounding properties and streets, which again we went over when we first started. The result of this excavation will not leave any holes or pits or anything of that nature. It's going to be used as a lawn area behind the house for the Eastman family. It will not create any depressed property values to the neighbors or anybody else in the area. And again, no changes in drainage. The activity will be in harmony in the general purpose and intent of the regulations. We don't expect any adverse impact, again, on surface water or groundwater. We talked about that, and you have the report from OTO, which again talks about that area. And just to reiterate, the directive from DEEP talks about wells within 500 feet, and we're finding that the wells, other than the Eastmans, are a little further away than that. So we don't expect any issue with wells. The work will be done in conformity with the proposed plans. During the period of excavation, the S&Es will be kept in effect, and the site will remain safe for the Eastman's family and the workers that are there. There will be no equipment coming in and out. As I said, the equipment's there. There's going to be no processing of any rock there.
Jay, that's not correct. We got to bring in blasting machine in and that. They're no longer on site.
They're not there. Okay.
So just correct that before you.
All right, I will correct that. The equipment was there, it's left, and will have to be brought back in terms of the mats to cover the blast area. So there will be some minor truck traffic coming in, and that comes in off a mountain road. During and after the excavation and the grading and topsoiling, the site will be clear of all debris. As I said, it will be a lawn area. S&E controls are in place and will remain in place until it is permanently stabilized and vegetated. There is no excavation conducted within 100 feet of a property line from any of the butters, other than I talked about earlier on the Schlestein side, which they have permission to go closer than 100 feet. And there is a little bit as well, not in excavation, but in filling, and now I'm getting into future phases, but again, that's located over in this area. On the side, next to the Diori property, and they also have permission from him with a letter that if you don't have, we will get you, it's allowing them to grade closer than 100 feet to a property. And I think that's a basic overview of our application. Hours in operation will conform with your regulations. Obviously, no work on holidays, no work on Sundays. Your regulations talk about 7:30 to 5:30 and noon on Saturday. And I think that probably is in keeping with the gravel operations that you've had in town over the years. So that's what's being proposed here. There will be a bond required for S&Es and as well for restoration.
Excuse me,
Jay,
excuse
Carl,
me 1 minute.
Congressman.
This is Jill Conklin. Carl Walton has a question.
Carl Walton here for the record. Jay, what map are you looking at? I mean, I have one that is emailed me that's labeled "40 Halley Lane." Is that the only map you're looking at?
Is it sheet 1 of 1 and it says site plan in the lower right corner, Carl?
Yep.
Yeah,
It's dated 7/20/2020.
that's correct. So that is the work area of the application that you have before you tonight, just for 40 Halley Lane. Okay, which is the third of an acre more or less that I described, which is a hatched area.
Yep, that's directly behind the house.
Right, exactly. Correct.
You mentioned property belonging to someone named Fiore. I don't see their name anywhere on this map.
No, it is not. It's
Okay.
actually in future apps that you will see, and it's off to the north and to the west.
Is it part of this particular application or not?
It is not.
Thank you.
So as I was saying, there will be a bond that will be put up. Typically, that's a number that's established by us, reviewed by the town engineer, Jeff Ford, and we will come up with that assuming this is approved, and that will be in place prior to any of this work commencing. So as I said, that's a basic overview of the application. We're confident that our plan conforms to all the requirements in your excavation section of your regulation and within your special use permit section of the regulation. So that said, if any of the commissioners have any questions specific to what I've described to you, I would be happy to answer them at this point.
Carl Walton for the record. You mentioned report or reports done by Steve Jacobs on locations and potential effects of wells. Is that part of what you submitted with the application?
Actually, the Steve Jacobs is a memo. It's an interoffice memo from Steve to Jennifer Roy. It was dated 1/6/20, and it describes the O'Reilly, Talbot, and Oaken report, and it also gives the draft guidance document from DEEP with regard to blasting and rock excavation. And I can actually submit this. You probably have it, but let me give it to Jen now, because I have an extra copy here, and I've got it scanned in my file, so I'll submit it.
It's a special meeting, so Jennifer Roy for the record, it's a special meeting, so we can only talk about the documents that were submitted. But, so, do you want me to read this, Jill?
What is it, Jennifer?
Like Jay just said, it's a memo dated January 6th, 2020, from Steve Jacobs to myself, Jennifer Roy.
Carl Walton for the record. My only issue with that is that it's dated 1/6/2020, and I'm unsure of exactly how much work has gone on since that date, since those surveys were done, that wouldn't be considered in his opinion.
Commissioner Walton, Jay Ursary, and J.R. Russo. So it's with regard to the O'Reilly, Talbot, and Oaken report that was done, but as I had said earlier, the memorandum that Steve Jacobs sent out to us, and this memo or directive from DEEP talks about wells within 500 feet, and the only well that we have that is less than 500 feet is the Eastman's well itself. There are no others. So technically, I would say that it's not even pertinent, but they went ahead and did the report anyway in the study, so I thought it might be something you'd be interested in seeing.
Jennifer Roy for the record. Carl, did you want me to read the memo? It's very short. Carl Walton.
Yeah, I'd like to know what he had to say.
Okay. So, it's regarding 40 Haley Lane. Per your request, I have reviewed the report dated November 1st, 2019 by O'Reilly, Talbot, and Oaken for the above referenced property. Elevated arsenic has been detected in isolated pockets of town, but all known occurrences have been associated with the Portland Arcos formation in the western and central portion of town. As the report indicates, arsenic is not a concern for this location. However, the properties in this portion of town are mapped in the Glastonbury Genesis Formation, see attached, which has been found to contain elevated uranium and radon. If a permit is to be issued, I recommend a pre- and post-blast survey following Connecticut DEEP's draft guidelines, also attached, of all neighboring wells with the addition of uranium and radon added to the water analysis. And attached to the map of the area in DEEP and a draft of the DEEP guidance document for evaluating potential hydrologic impacts associated with blasting and development.
Thank you.
Thank you for reading that, Jennifer.
You're welcome.
So, this is Jill Conklin speaking, for the record. It's been hard to follow this because I know Jay's pointing at things and discussing things, and I'm not seeing that. So, I just want to point that out there. I'm not really sure where everything was. Does anybody else have any questions for Jay or Attorney Merriam on the zoning board here? Is the applicant ready for us to open it up to the public?
Madam Chair, Jay Ursary again with J.R. Russo. Maybe just to clarify a little bit, and I understand it's difficult with these Zoom meetings to really be able to get a good feel for what we're talking about and what's going on, but I think we all know where 40 Halley is and where it comes off the cul-de-sac.
Can you talk louder?
Where the Eastman's house is located up towards the top of the hill. And just as a point of reference, I guess, let me just say this, that all of this work that we're talking about with the application that you're considering tonight is within 200 feet of the back of the Eastman's home, right behind their house. So we're on 40 Halley itself. We're in very close proximity to their home, and all of this work takes place within about a third of an acre just behind the house and within about 200 feet at the farthest point from the rear corner of their garage.
Okay.
Hopefully that gives you a little better...
A little bit. I do have the map here in front of me. On my iPad, I'm looking at it, so. But all of this is Jill Conklin for the record, all of their removal is on 40?
For this application?
For this application, yes, everything is on 40.
Okay. Jill Conklin for the record. Jay, are you ready to open it to the public?
If the commission has no more questions, I don't have anything more to add at this time.
Okay, so at this time we're gonna open it up to the public for public comments.
Jill,
and
yes, John.
John
Parks.
Before you do that, I have a letter that Jay referred to from the abutter Schlafstein, who is the one that's close to the area relevant to this application. I just wanted to make that part of the record as well.
So that's going to go in as, this is Jill Conklin for the record, that's going to go in as a public comment, correct? Is that what you said? I couldn't really hear Attorney Parks very well.
Sorry, that's part of our application.
Okay, so why don't you guys finish your presentation and then let me know when you're done.
I will.
Carl Walton for the record, so it's not part of your application?
It is part of the
It's part of it
application
now?
because Schlafstein is the abutter closest to 40 Halley Lane.
You can't add to your application. This is a special meeting with the public hearing, and under the executive orders, everything has to be posted 7 days ahead of time. If you want to submit this for the record,
Yeah, you can. Dwight Merriam speaking. The J. Ussery testified as a fact witness to the fact that these two abutters had agreed that the work could be had within 30 feet, and what John Parks is doing is providing that documentation, but it's not necessary for the record. It's not new evidence for the record, it's documentation of the fact testimony of J. Ussery.
Additionally, he mentioned the agreement with the other abutter, Fiore, which I'll submit this as well.
That's not part of, Carl Walton, for the record, if that's not part of this application, why would you want to submit it?
Good point, Carl. I changed my mind.
Carl Landolina? Jennifer Roy?
Yes.
So this first document, land clearing and regrading agreement, you were following what Dwight suggested, that it's documentation to Jay's statements? Should I read this and take it in?
Well, it's up to the applicant as to whether they want the document in the record or not. I mean, we've had testimony from Mr. Ussery as to the contents, I believe, of the document. If taking it in presents a timing issue with respect to when the commission may act on this application, I guess would be up to the applicant to decide whether that document should be placed in the record or not.
Jill Conklin, for the record, is that simply a letter from a neighbor saying they're okay with this situation? Is that what it is?
It's a copy of an agreement.
Oh, it's a copy of an agreement. Okay. Because I was going to say, if it was just a letter, and they wanted someone to read the letter into the record, that's one thing, but
Carl Walton, for the record, so it's a copy of an agreement that we should consider when we consider whether or not we will accept the special use permit. And they're not sure that we should see it. Or am I misunderstanding?
Jill Conklin, for the record, I think they want us to see it, but they didn't give it to us ahead of time.
Jennifer Roy, for the record. Carl Landolina, I am incorrect, right? That anything we take in tonight would be for the record, for the public hearing, since we're under the executive orders right now.
Yeah.
And taking something in and not posting it 7 days prior, unless they just want to read it into the record as a statement.
Dwight Merriam speaking. As I said, Jay Ussery testified that there are agreements with the two neighbors for work within 30 feet. That's sufficient for the record. If any member of the zoning commission would like to meet Jay Ussery under oath, I'll put him under oath to take his testimony under oath. But we don't need to put those documents in. We thought the question would come up, did we have any documentation of it, so we decided to bring them along. But if it raises an issue for the town attorney in terms of compliance with the executive order, I don't want to get into a debate about that.
Right.
We don't need either of those.
Right, and I just want to make sure, Jennifer Roy, for the record, that having seen what's gone on in this zoning commission, it kind of sitting here for the zoning commission over the past year and a half with all of the applications, now under these COVID executive orders, I want to make sure that what we do is the right process.
It's really not necessary. But if any member of the commission desires to have that fact testimony by Jay Ussery under oath, I'll put him under oath and put it in that way.
Rather than, you don't want me to just read it in for the record?
You can go, if it's okay with the town attorney to read it into the record.
Jill Conklin, for the record, I would like to defer this to our attorney, Carl Landolina, our town attorney, and have him chime in and give us some direction.
Well, again, this is Carl Landolina, again, as I indicated, and I searched for, in the executive orders, the one that applies to documents being submitted in advance of public hearings and placed on the website. So I wasn't able to find that section. Jen, were you able to find something after we discussed that earlier today?
Nothing more than what we've discussed.
Yeah, well, hold on a second. The main, again, for the record, Carl Anthony, the main executive order that deals with these kinds of hearings is 7I, Section 13, Section 19. And I don't recall seeing anything in there about that. There was some discussion, perhaps in a subsequent order.
Right. Carl?
Yes.
Jennifer Roy, for the record.
Mm-hmm.
Apparently, one of the residents that are listed on this agreement is here, so maybe she can just stand up and speak for the record.
Well, first of all, again, Carl Angelina, it's not our duty or obligation to make a presentation to the applicant. If the applicant would like to do that and present that oral testimony by one of the other parties to the document, that would be entirely up to the applicant. I guess under the circumstances that would be appropriate.
So you just want to add this.
So I'd leave that to
We won't put either document in. We know that the individual just spoken of intends to perhaps speak this evening. She could speak to that. And we will rest on the testimony of Jay Osuri that there are agreements with the two neighbors. And as I said, and I reiterate, if any member of the commission is uncomfortable with that as the sole representation of the fact that we do have permission from those two neighbors, I will put Jay Osuri under oath and take his testimony that way. I'm sorry for the inconvenience of this. We all struggle through the new rules of the pandemic to try to figure out what's exactly right, and I appreciate your desire to make sure that we conform in all respects to the executive order. So it's really not critical to where we are at this point.
So you want back for now.
Thank you.
Okay, Jill. Jennifer.
I had a hard time hearing Attorney Merriam.
Dwight is just going to stand on the testimony from Jay Usuri right now about the two agreements and basically carry on with the public hearing.
Okay. Thank you. So where are we? Is the applicant still presenting?
You all set for now?
That completes our... Dwight Merriam speaking. That completes our presentation. Thank you, Madam Chair.
Thank you, Attorney Merriam. So with that said, we're going to open it up to the public, and we're going to ask that you, I guess, are they going to be able to come forward, Jennifer? To speak into the microphone? Is there a microphone set up?
Yes, there is a microphone.
Okay.
And if they speak loud enough, it would...
Can they hear me, do you think?
Yes.
Yes? Okay.
Yep.
So, when you come up to comment on the application, you're going to need to come up to the microphone and speak clearly into the microphone, state your name and address, because there's some audio issues. Just if someone's not close enough to the microphone or speaking clearly, and then every time you speak, you must state your name. Anybody that speaks must state their name. So, I don't know if you had a sign-up list. Did you have a sign-up sheet?
No, I don't. I will just write their names.
Okay.
Jill, is the...
Do you want to go ahead and conduct it since I'm not there to...
Yeah, they'll come up one at a time, but yeah.
I mean, do we want to take people on the phone first, or, you know?
I don't know. If you want to take the phone, people, or people that are here in case they want to leave and not remain sitting in here. However you see fit.
I think it's probably harder to be on a phone than be sitting in a room. So I'm going to ask if there's anybody on the Zoom call that wants to speak in favor of the applicant. They can unmute themselves, state their name and address, and have a word. Is there anybody in the audience there that would like to speak in favor of the applicant? They can come.
Yes, I would. Yes, I would.
Are you?
We do have one.
Are you on the phone? Phone call?
Yes, I'm on.
Okay.
I'm on the phone.
Go ahead, state your
We have a
name and
caller.
address and...
My name is James Fiore, and I live at 110 Long Hill Drive, and I'm the most direct abutter to the Eastman property. I think that it is more reasonable to allow him to do the blasting to complete this project. I viewed it myself. I saw what he's done so far, and I'd like to get it over with as quick and as efficiently as possible. I think that the blasting is the only thing that would make any sense. The jackhammering is a nuisance, and it's going to take a lot longer. I believe that he has the right to do this. This is on his property, and he's disposing of the refuse from the demolition on his property. And I would say that I have no objection, and I would be in favor of this being allowed. Thank you.
Thank you, Mr. Fiore. Is there anybody else on the phone that would... This is Jill Conklin for the record. Anybody else on the phone that would like to speak in favor of this applicant? Okay, so we're going to take it back to the live auditorium for anybody in favor of the applicant.
This is Janet Schlossstein at 155 Mountain Road.
Hang on a second. Jill, can you hear?
Yes, but Mr. Fiore has to mute his phone. Thank you. Go ahead.
Can they see you, Jennifer?
I cannot hear who's speaking.
Show them that.
I can.
That might help her understand.
What's your address? What is your address?
155 Mountain Road. And the west side of my property is almost the entirety of the east side of 40 Halley Lane. So it's at the top of my backyard where this blasting would be happening. And we've been living through the jackhammering. But we're in favor of the blasting. We would like to get this over as quickly as possible. We have been up to the site several times. We've had our own engineers up there, and we feel perfectly safe. And since we're probably the closest, our well is the closest, our dwelling is the closest, I think that everybody else can rest assured. I know I can feel the daggers in my back, but I don't want to upset anybody. But we've done our homework, and I think everybody it's going to be okay. We're not going to have a problem. That's it. Thank you.
Thank you. Jennifer, are you asking them to come up? Because I can't see if there's like a line or what they're doing.
There's no line. Is there anyone else present to speak in favor? We have another person.
Thank you.
Hi, my name is Dean Giacello. I live at 118 Stafford Road in Summers. I'm friends with the Eastmans. I think that they've covered their bases and exhausted thousands of dollars in research to make sure that everything's going to be copacetic. I am strongly in favor of, and hoping that you'll be in favor of letting them finish up this process. Thank you.
Thank you.
Anyone else to speak in favor? No one else.
No, so this is Jill Conklin for the record. So at this time, we're going to open it up to anybody in opposition of the applicant. And please, again, state your name and address and try to talk into the microphone because I know I'm having trouble hearing. You can just come up one after the other and state your name and address.
Are you doing the phone first, Jill?
Yes, anybody on the phone that would like to unmute themselves and speak. You can do so by unmuting yourself from the Zoom call.
Hi, this is not an abutting property owner, but it's Tim and Kathy Welch from Mountain Road, and it's number 168. We've had a number of issues here with the fact that the zoning board and zoning what the town has presented and stuff has been ignored. After cease and desist orders were made, blasting and everything else continued. Generally in violation of, as nearly as I can tell, and I'm not an official of the town of Somers, I'm not an attorney, we got a broken window in the back of the house, and maybe it's our fault for owning a stone house, so it doesn't have any give, but we've had a number of disruptions here, and it seems to be a general wish not to abide by the ordinances of the town of Somers and the cease and desist, like I'm repeating myself, and everything else. Blasting versus hammering and stuff. It was said that there's no planned structures, but is that going to be transferred into the deed? What about the future? Is that going to be written into the plans for future people after the Eastmans have gone? They were talking about 9,650 cubic yards. Is there anything else? Now, all of a sudden, things have changed, and they're not going to be removing the materials from blasting. They're going to be put elsewhere in the lot, but I have concerns because that's over 240 40-yard dump trucks of material by my calculations. I just wonder why cease and desist orders were ignored and why we should respect this most recent application. Thank you.
Thank you. Jill Conklin, for the record, I didn't catch his name. What was his name?
Tim Welch.
Tim Welch, like W-E-L-C-H, like grape juice.
Yep. Thank you, Jim.
No, Tim, with a T.
Oh, Tim. Okay. See?
Like Keeney.
Thank you, Tim. Is there anybody else on the Zoom call that would like to speak in favor, against the applicant, opposition? If you would like to, just unmute yourself. So I guess at this time we'll turn it over to the live meeting at the town hall, and Jennifer can kind of take over and keep people moving. And if somebody is on the line that does want to speak and they, change their mind, just, when we have a break in between, you can just unmute and let us know.
Hello, I'd like to speak.
Sure. You can just state your name and address.
Hi, my name is Peter Riley. I live at 6 Amy Lane, Somers, Connecticut. And my wife is Kelly Lewis, and she also lives here with me at 6 Amy Lane, Somers, Connecticut.
Okay.
I would like to say that I do not have issue with the Eastmans doing a project with their own property. As you know, I consider it their own property, and what they want to do to it is at their disposal. And the only thing I would ask is that whatever they do is between normal business hours, between 8 and 5, 9 and 5, Monday through Friday. But it is their own property, the same as I would consider myself having a pool put in or a major landscape project on my own property. It's a very stone area, and you know, in order to do that, they need to, you know, take appropriate measures to do such in order to excavate the land properly. And just because of the size and scope of their project, they should not be penalized. And that's what I have to say.
Thank you, Peter.
Hello, my name is Scott Soares. I'm not sure if you can hear me now. Can you hear me?
Yes, we can, Scott.
Fantastic. Thank you very much. So I'm calling in on behalf of my aunt. If I can give you my address, I live at 39 Albemarle Road in Longmeadow, Massachusetts. But my aunt, Carol Folkowski, who's had difficulty getting onto the call, lives at 19 Root Road, a property that directly abuts the applicant's property. And she has very significant concerns over any disruption to her property and her home that was built in the early 1700s. There's no certainty that any of the blasting or rock splitting, hydraulic or otherwise, will impact vibrations that could have damaged her home, or any certainty that if that damage occurs, that it would be repaired. So I know as she spoke at a previous hearing that it sounds like this application is very much like one that was already denied, and like the first caller that spoke about the Eastmans ignoring a cease and desist and go ahead and doing work on the property regardless of town bylaws. She remains very concerned. In fact, walking her back property, it's pretty apparent that the Eastmans also have little regard for the neighbors as well, given the trees that have fallen across her property line and the lack of maintenance on that property itself. So, like the first caller, my aunt, Carol Folkowski, she remains very concerned about negative impact to her home, as well as the water quality issue that was brought up without any testing done by the Eastmans or anyone else on her water ahead of all of this. There's no way to know to what extent this activity that's removing a substantial amount of material, even if it's on the same property, won't have any negative consequences on her own property, and she needs certainty that that will not happen if this permit goes through. So she opposes this special use permit. Thank you.
Thank you, Scott. Is there anybody else? This is Jill Conklin for the record. Anybody else that's on the phone would like to speak? Just a heads up, you need to press *6 and toggle to the mute. I don't know if you want to chime in on that page. I don't know if I'm saying that right.
Can anybody hear me?
Yes, we can hear you.
Oh, okay. That was my nephew that just spoke. This is Carol Folkowski. I was a little bit late getting in, and he's absolutely right. I do live, our land abuts his land, but now there's the road that goes through. Like I said, the house is completely brick, 1700s, the noise, the shaking, and matter of fact, when they were blasting, you could obviously, if you sat down on the grass, you could feel and hear that noise. So I've been hearing that noise since it started. Now, I would appreciate it, you know, if they would just kind of wake up and smell the roses, you know, and give us a chance. I mean, we are tired of it. We're tired of it, damn tired of it. And that's really all I have to say. I could say a lot more, but I'll just get more mad, so I will close that off right now, and I thank you for your time.
Thank you, Carol.
You're welcome.
Is there anybody else? Paige, did you want to run through that process?
Oh, yeah, it's just to turn your mute on and off.
you can hit *6 on your telephone if you called in by phone only.
Who, me?
Hello? Hello, is there a moment just for one more comment?
Absolutely.
That's why we're here.
Okay. My name's Kelly Lewis. I live at 6 Amy Lane, so I'm just down and around the corner. And I would love it to see that people who own their homes and take care of their homes very well can just complete a project, you know, preferably during business hours. I don't mean 7 a.m., I mean like 9 a.m., and I kind of like it done before dinner, like 4 p.m. I'd also appreciate it if it weren't on the weekends, so we can enjoy the weekends. But I'd like to see people be able to complete their project. And I'd rather see it just get done and be done. You know, and maybe we could just ask for a timeline. Just a thought. Thank you.
Thank you, Kelly.
You're welcome.
Hello, this is Hemant Panchal. Hello.
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 I didn't catch your name.
This is Hemant Panchal. Hello.
Yes, Emmett Petchel.
Yeah, I live at 92 Highland View Drive, Summers. And I'm in favor of what he wants to do on his property. He wants the property. He takes good care of the property. He does understand the problems with the neighbors. He's trying his best to reduce the problems. So I hope he can finish the job. Hello?
Yes, we're here.
Yeah, so I'm in favor of it.
Thank you.
Thank you.
Once you're done with your call, you have to *6 again to mute yourself. So anybody that's not speaking.
Hi, this is Peter Wiley again.
Hi,
Hello?
Peter. Yep, we can hear you.
Yes, at 6 Amy Lane.
44 long.
44, I would like to say, you know, what Dan Eastman is on his own property, and at 44 Long Hill, right next to us, I think that's a more pressing issue for the town and for the neighborhood, where we have illegal Airbnb going on next to us, where we have people from New York City that are staying there.
Excuse me, I'm going to inject because the Airbnb is not part of this application. We're only going to talk about 40 East, the Eastman's property at 40 Halley.
All right, but I think illegal issues are more pressing than this.
Thanks, Peter. Is there anybody else on the phone that would like to speak? *6 will open the line for you. I feel like an operator. Okay, so let's take it back to the town hall, Jen. You can have people that are there.
Whoever wants to speak first.
Hi, this is Joseph Igler. I'm at 159 Mountain Road. So I want to start by reading a definition from the Merriam-Webster Dictionary of precedent, an earlier occurrence of something similar or something done or said that may serve as an example or a rule to authorize or justify subsequent acts of the same or analogous kind. Now, the reason I'm starting off with this is because of the fact that the Eastman...
Can't hear him.
You have to speak into the microphone.
You're going to get right in front of it.
Okay, sorry. I'm just trying to be careful considering
Yep,
that...
that's much better. Much better.
Did you want me to start over?
Yes, please.
I will happily.
I didn't even
Just
get
give me
your
1 second
name
to
or
get back to
anything,
my phone.
So start with your name and address.
Absolutely. So my name is Joseph Figler. I am at 159 Mountain Road. And so I want to begin with reading a definition from the Merriam-Webster Dictionary for the term precedent. A similar occurrence or something similar. Number 2, something done or said that serves as an example or rule to authorize or justify a subsequent act of the same or analogous kind, or a person or thing that serves as a model. That that last one I don't really care as much about, but the reason I bring precedent up is the fact that throughout this entire process, the Eastmans have shown a precedent of not caring what the town has to say. Back in June of 19, where this application was submitted for 12,000 cubic yards of rock to be moved and adjusted and blasted, the similar questions of environmental as well as damage done to the surrounding properties were brought into question. That application led to a cease and desist on the property in September, a second cease and desist that occurred in April, in which Mr. Eastman, in a conversation I had with him during the last zoning appeal meeting, stated that he finds that his lawyers are more important than what the town rules. Now, the fact is that the Eastmans have been going on continuously. In fact, during the zoning board of appeals first meeting that happened a few weeks ago, Mr. Parks had stated that he had understood that it was a cease and desist or appeal, meaning that because they were appealing, they were justified in doing construction for 6 weeks straight and doing continuous jackhammering. Numerous emails were sent to the town advising of this, and the town either A, didn't respond, or B, didn't give clarification needed to find out why this wasn't going on. The fact is that even in this room right now, their party has shown a disregard for what authority has stated.
Madam Chair, Dwight Merriam speaking. Point of order for the chair, please.
I'm sorry, I thought I had the time to talk.
I'm representing the applicant here.
And I have a time to talk until I'm finished.
Madam Chair, may I have a point of order, please?
You're not allowed to interrupt.
This is Jill Conklin for the record, okay? We're gonna let the public speak, and then when they're done, you can address them.
My point of order, Madam Chair, is that this testimony is irrelevant to the proceeding here this evening.
Oh, I think it's very relevant, considering precedent is exactly what this whole thing is about. The fact of the matter is that the precedent of what's happened occurred is that's the entire heart of this problem. It's why we are now at another process of them submitting an application to remove now 9,600 cubic rock. Last time I checked, rock doesn't magically vanish. Rock doesn't just disappear. So where's the other rock? Where did it go? Oh, I know. They've been working on it and trying to remove the rock however they feel like it, again, ignoring cease and desist that are on public record, and in fact was upheld by the Zoning Board of Appeals, in which Mr. Eastman had attempted to sue the town in order to basically get it removed because he felt the Zoning Board of Appeals had bias against him. The fact of the matter is that the Eastmans have continuously ignored what the town has said, and I have zero faith that no matter what goes on here, the Eastmans are going to abide by it. Even if he does present us with every single thing here, he's presented a report that I don't know how they got the information for 159 Mountain Road, because we've never seen anybody show up to talk about our wells. We've never shown anybody here who's actually come to actually measure stuff, actually see whether or not anything is going to be fine, and our property is right at the bottom of that potential landslide. The fact is that the Eastmans continue, again, to not care. And that's the whole thing. If I do something wrong, I am held accountable for the actions in which I do wrong. If I was to break the law, I would be arrested. If I was to break the rules of my company, I would be fired. I would not be then said, oh, well, I could reapply and then try to do it again. There are no do-overs in this, and the fact that the town is continuously doing these special meetings for the Eastmans for this is also very disconcerting. Yes, you have a whole bunch of people here who have been, who are quote-unquote friends and family of the Eastman, who have been calling in that they are in favor of this project. But they're the friends and family. They're not the ones that have to deal with the jackhammering, that was dealing with the jackhammering for hours upon end. They're not the ones that have to worry about uranium in their wells. They're not the ones that have to worry about the skyline. They're the ones that are far away who the Eastmans just happen to call in. The people who are here who are against this are the people who are actually the neighbors The people who have actually been dealing with this for the past 3 years, while the Eastmans do whatever the heck they want to do and snub their nose at the town accordingly. So the fact of the matter is that what I would like to see happen is that I would like to see this application be thrown out, and if you want a very nice stop to the whole proceeding, have them just stop doing the work. That'll end everything right out of the gate. Thank you.
Okay. Anyone else to speak?
Thank you.
Jen Grigger, 24 Amy Lane. I need to wipe down the microphone first for growth. Can you hear me okay?
Yes.
All right. Nothing at 40 and 42 Holly Lane with regards to blasting, excavation, jackhammering, fracking, rock splitting, drilling, or the use of easement for excavation and construction equipment, including choosing their own work hours, has ever been permitted to our knowledge, nor is found in the public file. The only exception was 1,000 cubic yards allowed by the zoning commission in May 2019, only after Bay State Blasting had already drilled and loaded the holes with explosives, making it a safety issue that forced an immediate decision. The applicant contractors failed to advise of the blasting that had already been done in 2018 for 5 weeks without proper permits. They left out how they brought up tractor trailers with blasting mats and other equipment, misusing easement, jackhammering, excavating the easement to 40 and 42 Holly Lane properties that is less than 40 and 90 feet from actual home structures that the easement lies between. At that May 2019 zoning meeting, you were never advised of the excavation in 2017 and 18 that opened up the area on both 40 and 42 Holly Lane. The 30 to 40 foot tall boulder were retaining wall, the taking down and bringing up of material, and continued misuse of an easement by Passing Construction. In fact, I think you were blindsided by what you heard at the one and only public hearing in June 2019. Since that time, cease and desist were issued in July 2019 and again in April 2020, but continually ignored by the applicant. However, the ZBA upheld the cease and desist issued and rejected a proposed settlement plan just last month. The applicant appears to surround herself with contractors that disregard and willfully violate regulations and cease and desist on the property. Passing Construction has been quite involved in 2015 when creating a road that would have required a special use permit due to clearing, leveling, jackhammering, excavating, bringing in fill, etc., though most was not allowable for regulations and being in an A zone. Then there was the enormous level of clearing and logging, excavation, removal, and fill on both 40 and 42 Holly Lane since 2017 to July 2020. Then jackhammering 11 days a week, 6 days a week, or 11 hours a day, 6 days a week from April until July of this year. Passing Construction was issued a cease and desist, but still continued to work until the zoning enforcement officer filed a complaint to the Department of Consumer Protection. Once his license was at risk, it appears to be the only reason he stopped violating town regulations. Bay State Blasting appears to have blasted 5 weeks in 2018 without proper permits and no pre-post testing and inspections of wells and structures, nor proper notification that is the industry standard. They began fracking, splitting the day after Passing Construction left once again doing the work that requires a special use permit. Bay State Blasting appeared to have stopped work only after they were issued a cease and desist. Mr. Parks, after approximately 40 years of practice, misunderstood a cease and desist order with an interpretation of a cease and desist or an appeal at the ZBA meeting. That's concerning to me for a practicing attorney to misunderstand such a basic procedure. His strategies of applying and withdrawing wasted so many town resources and property owners, but gave time and a green light to his client to continue to violate regulations, as it appears to so many of us who witness it, listen to it, and feel it. Mr. Merriam's apparent use of a dictionary definition strategy to pick apart a single word that is standard in regulations found throughout Connecticut. His letter stating regulations did not apply to his client, but more time and has wasted more town resources, also appearing to give the green light to his client to continue work. Maybe because I'm not knowledgeable in legal matters, this is just how it works, but it all seems questionable to myself and many others. Interestingly, today we are here for a public hearing in which the attorneys appear to have conceded that the permitting process must be given a chance and heard by a zoning commission and the public concerns heard. So hear this. Department of Energy and Environmental Protections and Connecticut Department of Public Health both advise neighbors to test specifically for uranium and radon that is associated with blasting and heavy excavation. Both recommended this be done pre and post blasting and excavation and retesting annually until stabilization. But this is not offered to anyone that I'm aware of. These tests are $450 each time. My water quality has changed since our home was purchased and required mitigation for high levels of uranium that has cost $6,000, but does not include the upkeep of materials needed to maintain and keep my water safe to drink. The town sanitarian has also supported these test recommendations by DEEP, acquired test kits and taken samples that are being performed by the state currently. Results are pending. I would hope the town seriously considers the effect on neighboring properties, not only the outrageous noise, but the money has cost so many of us to test and mitigate well water changes that should have been protected by the town enforcing regulations and following procedures in the first place. It appears to be a permanent condition. This year is reassessment year, and having a quarry in your neighborhood isn't exactly going to improve home values. In fact, this past year, houses in the neighborhood have sold for significantly less. And speaking to realtors in the area, they are aware of the ongoing unpermitted excavation and blasting, which had to be disclosed to their clients. We'll be seeing the ramifications this fall. Maps compiled by other sources don't appear to me to include all the current changes in the excavation and jackhammering of the last few months that can be seen from aerial and satellite images. A boulder retaining wall, quarter-mile long rubble walls that are 20 feet high are visible to many properties and are some of the changes not easily seen on the site map. And since I'm not a surveyor engineer and the site maps were compiled from old survey maps, as a suggestion, it might be time to get an independent surveyor to the site, or the site map to the topography and other landmarks, then report back to planning and zoning commissions before any decisions are made. Site maps for prior applications have left off details such as the ingress and egress road to the work site, as I recall. Without full knowledge of what is taking place, and likely none or few of you are surveyors and had access to the site, planning commission, as well as yourselves, may not know what to look for or ask, and it would be the only legally responsible option given the mess you have now. The devil is in the details, and if you're not familiar with that phrase, it's used for saying that something may seem simple, but in fact the details are complicated and likely to cause problems. You all have no idea what we've been through with the noise, the inability to even sip coffee on a weekday or Saturday morning outside on your porch on a summer day. Wake-up revelry at 6:45 to 7 a.m. with excavation or jackhammering heard inside our closed-up homes. While you're probably hearing these details for the first time, we've been having to live through this. Mr. Landolina has validated all of our concerns in the past couple months and confirmed that, in fact, all of the regulations we knew to be violated have been and require at least a special use permit, and most are not allowable regardless of a special use permit. We're at a loss for why 2 injunctions were obtained through the courts and then rescinded instead of keeping them in place and letting the permit process play out. This application is nothing more than an attempt to legitimize and expand on the work that the applicant's attorneys claim do not apply to them. We expect to see careful consideration and no detail left untouched. This property owner and his attorneys appear to use strategies to ignore or manipulate regulations, using techniques to confuse and deflect that the rest of us know to be true and agree to abide by as part of living in Somers, Connecticut. When you render a decision, please take into consideration all that we, the neighbors and butters, have been through and will continue to go through going forward, and not just the non-compliant property owner. You are tasked with setting precedent for all the town residents and contracts going forth to continue to uphold and protect town regulations to ensure the reasonable use of our properties, our health and safety, property values, and to conserve and protect groundwater and drinking supplies, and so much more. Thank you for your time and consideration. This is still Jen Grigger at 24 Amy Lane. I have satellite images that if you'd like to take. Okay.
Thank you, Jen.
So the satellite images are from Google Earth, and they can be seen, like anybody can do them. But you can see the progression from the time, actually it goes all the way back to 1999, I believe. So you can see the progression yourself. You don't have to see my pictures. You can take a look online. Thank you.
Anyone else wish to speak?
Harwell, for the record, did Jen Grieger just give you copies of those photos as part of, to submit as part of the record?
Yes, she did.
Okay, thank you.
Hi, Andy O'Learsick, 47 Long Hill Drive. Statement on behalf of my husband, the co-property owner, and me. We strongly urge the Zoning Commission to deny the special use permit for application number 20-009 at 40 and 42 Halley Lane. I've heard a lot this evening about people who are saying, let's just get this done, and I feel like that should not be our answer. Just because it would be easier to get it done doesn't mean it's right, and we all have zoning regulations to follow, and they exist for a reason. My husband and I have been property owners in Summers for over 6 years. Prior to the time that we purchased our home in 2014, we conducted well water testing. And while there was some radon in the water, it was below the actionable level of 5,000 picocuries per liter. Additionally, testing revealed we had hard water, so there was no indication that we needed a water softening system at that time. After a number of concerns were raised by neighbors about changes in the water quality in our neighborhood that seemed to arise after extensive blasting and unpermitted excavation by the applicant, we had our water retested in September 2019. The same lab conducted the 2014 and 2019 tests. Our water hardness changed considerably, and the radon and water numbers increased dramatically. And we also found that we have uranium in our water, something that we and most homeowners did not test for back in 2014. While we have not yet taken steps to prove the causation of these water quality changes, one of the initial assumptions made by a trained professional reviewing the matter is that the prior unauthorized, extensive, and unpermitted blasting and excavation done on the two properties since 2018 contributed to the dramatic change in water quality. Specifically, after contacting the State of Connecticut Department of Public Health's Well Water Program, officials at the State of Connecticut's Department of Energy and Environmental Protection, as well as an area well water company, we were advised that while radon and water can fluctuate over time and during different seasons, our dramatic increase in radon, our levels were 2.5 times the amount at the time that we purchased the property, coupled with a 38% increase in water hardness as compared to 2014, were not natural fluctuations and pointed to man-made or artificial causes. We then discussed that there was a large amount of blasting and excavation in the neighborhood, which the department officials stated could have led to new fissures being opened up in the rock, impacting where and over what type of rock the groundwater was traveling, and potentially releasing additional naturally occurring radon and uranium from the bedrock into the water. As a result of the reduced water quality, we have paid thousands of dollars to improve the safety and quality of our well water in order to protect not only our family's health from the potentially adverse effects of these contaminants, but also to protect our home's plumbing and appliances from the detrimental effects of our now very hard well water. And from talking with other neighbors, we are not the only ones who have faced a deterioration in well water quality and have had to install a water treatment system or are looking into installing such a system. Candidly, the high number of water quality issues that abound in our neighborhood create another worry. As news spreads of the water quality issues in the neighborhood, there will be negative effects on property values. Honestly, I think the town could have done more to stop this and to curtail the applicant's previous blasting and excavation activities. The town and the applicant have denied us the opportunity to conduct pre- and post-blasting excavation testing in order to fairly and accurately assess the impacts of this activity on neighborhood wells and groundwater. The town has repeatedly told us and others that we should file a civil suit against the applicant and is effectively attempting to pass the buck for its own inertia, culpability, and negligence. Has failed to uphold its stated purpose to protect and promote the public health, safety, welfare, convenience, and property values, and to conserve and protect existing and potential surface water and groundwater drinking supplies and other valuable natural resources. It shouldn't be that we also have to sue the town and sue the applicant. The town should be doing the right thing to follow its own ordinances. While the applicant did engage an engineering firm that you've heard about this evening, O'Reilly, Talbot, and Oaken, to evaluate the potential impacts of the water blasting, OTO's report failed to consider both radon and uranium. Instead, it focused on arsenic releases, perchlorates, and vibrations, the latter of two which are also concerning. And as previously noted, when Summers asked its town sanitarian, Steve Jacobs, to review the OTO report, he noted that arsenic is not a concern for this location. However, the property in this portion of town are mapped in the Glastonbury Gneiss Formation, which has been found to contain elevated uranium and radon. He concluded by noting that if a permit is to be issued, I recommend a pre- and post-blast survey following Connecticut DEEP's draft guidelines of all neighboring wells with the addition of uranium and radon added to the water analysis. Thus, the report conducted by OTO is incomplete and does not fairly and accurately reflect the potential impacts of the proposed activity in the neighborhood. I would also like to add that I think it's disingenuous to say there isn't going to be a lot of truck traffic. I know Mr. Eastman indicated that blasting masks and equipment needs to be put there, but what about all the topsoil that has to be brought in? When you think of how much we're talking about, that's going to be a huge impact on the neighborhood that has already been affected by all of this activity. Frankly, I think the town needs to follow, and why are we taxpayers if we're not upholding the cease and desist orders, forcing the town attorney needs help, the town should be supplying him with outside counsel so that we can actually go to court, and we have an injunction already. It should be being forced to be upheld. I don't understand why the town has backed off of this. I think the town really needs to act and consider the impact to the surrounding neighbors, and it should deny this special use permit application. Thank you.
Jill, you're muted. Did you want to say something?
I was muted because I was making a little noise here. I just wanted to thank her for speaking, and guess we'll move on to the next. If there's somebody else that wants to speak.
Actually, sorry, it's Sandy O'Leary for 47 Longtail Drive. I'd like to actually submit my water test results if I could.
Mm-hmm.
Thank you, Sandy.
Edward DePoe, 18 Halley Lane. Can you hear me?
I can hear you.
My family and I are opposed to this application in its entirety. We are asking the Commission to please put a stop to the massive amount of work that has been going on and to prevent further blasting and fracturing of rock at 40 and 42 Halley Lane. This application claims that blasting will be used to minimize noise and complete the process quicker. While these means may benefit the applicant, they are not appealing to us. Countless studies have been completed on the negative impact of blasting and fracturing of bedrock and its impact on groundwater quality. It's impossible to completely control the energy produced in the air or the ground from a violent blast, which can open up new cracks, veins, or fissures in the ground. These cracks or veins can release harmful gases which negatively impact the health of humans. Our home was built in 1996, and in 2019 we had to have a water system installed to remove one type of odorless gas that is known to cause cancer in humans. Prior to the water test in 2019, this system was not needed. In addition to the health concerns associated with blasting and fracturing, there is a concern of concrete in this town. This town and many surrounding it are facing a concrete crisis, where many homes have foundations, septic tanks, and structures containing fragile concrete. To blast the ground which knowingly contains fragile concrete seems both reckless and inconsiderate. While some of these homes are visibly crumbling, others contain pyrite and are not yet showing signs of decay. The reason for this is not yet understood due to the fact that this particular concrete problem is new, but violently shaking the ground has been known to change the quality and movement of groundwater. and groundwater is known to have a negative impact on concrete containing pyrite. It is yet to be determined if blasting the earth has additional direct impacts on concrete, which contains pyrite, and it is our hope that our neighborhood in Summers does not become a case study in this area. In conclusion, we sincerely ask the Commission to uphold the zoning regulations that were put into place to protect the environment and surrounding homeowners. Thank you for your time.
Thank you.
Jen, may I take the microphone and sit there?
Sure, sure.
Good evening. Can everyone hear me?
No.
Let's try that again. Is this loud enough?
Can you all hear her?
She'll have to start and we'll have to see.
Okay. Good evening. My name is Dory Famigletti. I'm an attorney at Kahan, Kerensky, and Capicella, which is a law firm in Vernon, Connecticut. I represent the property owners at 175 Mountain Road, Tom and Vicki Clark, and we are here tonight to address their concerns over the proposed application, as well as the ongoing earth removal activities that have been occurring over the past 3 years on the Eastman properties. As you heard tonight, and I won't repeat what you've heard tonight, but also by the applicant's own admissions, as evidenced in prior applications, as well as court filings by the Eastmans, the applicant has been blasting and removing rock and earth from its properties at 40 and 42 Halley Lane for 3 years without a permit. They have taken advantage multiple times, and mind you, that's not permitted to take advantage of this exception multiple times, of the exemption for removal of under 1,000 cubic yards of material. They have filed multiple applications just to ultimately withdraw them. They've been cited under multiple cease and desist orders, and the town has brought at least 2 injunction actions against them, the most recent town action which is still pending. However, despite all of that, the Eastmans have ignored all orders to cease removal activities. Please permit me to submit to you some aerial photographs that show the extent and the extensive amount of the earth and rock that has been removed from the site to date. I'm not sure if any of you have had the opportunity to do a site visit of the property, but I think these photos speak volumes, and I'll submit them for the record. And now I would like to turn our attention to tonight's application. The application before you tonight is specifically for earth removal and excavation of rock at 40 Halley Lane. The submitted site plan, however, is inaccurate, misleading, and deficient in many respects and cannot support your approval of this application. The submitted site plan is inaccurate and misleading in that it doesn't depict the correct current property line of 40 Halley Lane. Rather, the site plan does note that there is just over 9 acres that the applicant proposes to merge into 40 Halley Lane from its abutting property at 42. The plan, however, shows this all as one and refers to the old property line as the original property line. This plan hasn't been approved and reviewed yet by the Planning Commission, and we cannot presume that the Planning Commission will just approve it. That would infringe on the exclusive jurisdiction of the Planning Commission. The Planning Commission needs to evaluate the lot line revision request. They need to confirm that no new nonconformities are created or that any existing nonconformities are not increased. They need to confirm general compliance with the regulations, and they need to determine that a code-compliant B100 area still remains on 42 Halley Lane. At this time, the depiction of the property lines are quite simply erroneous. In addition, the site plan depicts approximately 5.5 acres of the additional 9 acres as zoned A1, which is also erroneous. Presently, those 5.5 acres are zoned A, and as you may know, the regulations do not authorize the zoning commission to grant a special permit for removal of earth products in an A zone.
Now granted, a zone change application for those 5.5 acres has been submitted. That application is still subject to a public hearing and demonstration by the applicant to this commission's satisfaction that the zone change is appropriate and consistent with your town plan of conservation and development. That also has not yet happened, so it is premature to evaluate any earth removal activities associated with the land in the A zone. However, the majority of the activities shown on the submitted site plan appears to be located in the A zone parcel of land. And again, that's misleading and inaccurate. I would like to note that your regulations state that the site plan is required to be an A2 certified site plan if this plan is unsigned and clearly notes that it's a Class D survey. Perhaps if it was signed and certified as required, the site plan would not contain these referenced inaccuracies. The Commission's review of the application tonight is purportedly to consider earth removal activities on 40 Halley Lane. But how can you accurately do so when so much of the site plan is conditioned upon activities at 42, or at least a portion thereof? Again, we cannot presume that the lot line revision or the zone change application will be approved. We don't know that they will. So you as a commission need to be able to evaluate an application for earth removal at 40 Halley Lane as it stands now without regard to any of the additional land. I'd like to review with you what I see to find as the deficiencies in the application and aspects of noncompliance. In both the original narrative that accompanied the application, as well as the revised narrative that was posted online, the narrative states that the applicant proposes to remove 9,650 cubic yards of material. However, when you look at the plan, the area that is being removed clearly straddles the existing property line, which isn't quite shown as an existing property line on the plan. I would like to know, is this 9,650 cubic yards of material the entire material noted to be removed? And the note on the plan says area of material to be removed is 1.2 acres. Or is that the portion just solely on Halley Lane? We did hear Mr. Ussery say that the area of excavation on 40 Halley Lane was approximately 1/3 of an acre, but I have no idea if the 9,650 cubic yards is just the 1/3 of an acre on 40, or if it includes the extensive area of excavation also shown on the plans on 42 Halley Lane. I think you need to know that, because you as a commission are authorizing certain excavation activities, and you need to clearly state how much is authorized and how much of that material being removed is specifically from 40 Halley Lane. In addition, the original and revised narrative talk about the scheduled time for completion of this activity. The original and revised narratives say that it will take 2 weeks if blasting is permitted, and 8 to 12 weeks if blasting is not permitted. Now again, I make a note that this was in the original and the revised narrative, because the revised narrative removed any activity on 42 Halley Lane. So how long will the activity take on 40 Halley Lane? Just the 40 Halley Lane, which is all that is before you tonight. We did hear tonight a statement that the work could take 30 days. Well, which is it? That's even more than the statement of 2 weeks on the combined parcel. So there's a lot of inconsistency and unclarity here. And as a commission, again, if you're approving activity, you need to quantify that activity and have a specific time frame for when it may be permitted. Next, where will the material go? The application states, for purposes of tonight's application, that it's solely to remove rock, and the rock will be stockpiled on 40 Halley Lane, at least until the additional applications are approved and a separate special permit is authorized for the 42 Halley Lane excavation. But we need to know, you need to know, what happens if those contingencies never come to pass. What happens if the stockpiles if nothing with regards to 42 Halley Lane changes? Where will the stockpiles be placed on 40 Halley Lane? We don't know that. The plans don't show that. Will the new stockpiles ultimately stay on 40 Halley Lane if they can't ever be moved to 42 Halley Lane because the other applications are not approved? Or will they then be required to be trucked off-site? All of that is very important information for you so that you can properly evaluate the operation and trucking associated with the operation, and also make sure that the land is properly reclaimed and restored once the earth removal is completed. But the plans don't show any of this detail, and the applicant hasn't provided any either. The application, at least what was submitted and filed on the town's website, does not give any information on the depth to water table before and after the excavation, so that you as a commission can be assured, as your regulations require, that the final excavation is no closer than 5 feet to the high water table. We did hear tonight testimony by Mr. Ussery that the groundwater table is not expected to change, but we need some documentation to show that they have measured where the high groundwater table is, where the final grading will, where the final excavation will go to, so you can ensure compliance with your regulations, which is what you're tasked with doing. The site plan should adequately show erosion and sedimentation control, again, along the excavation that is part of this application. Everything in this application package deals with the entire property, which is 40 and 42. Again, what happens if 42 is never included? We need to show an E&S plan just for the excavation on 40 Hallie Lane. The applicant, has not given you any information regarding a breakdown of the cost of the work, which is necessary so that you can determine the amount of the required bond to ensure faithful compliance with this permit, as well as a complete restoration of the site once the removal activity is complete. Now, we did hear Mr. Ussery say that if this project is approved, he will submit that information to the town engineer. However, the regulations specifically say it's required to be filed with the commission. Finally, and perhaps most significantly for my client, the applicant has represented that access to the site will be via the driveway to 40 Hallie Lane, as well as the access easement that exists to 42 Hallie Lane. However, your regulations specifically provide that access and egress to and from the site must be at least 100 feet from side and rear lot lines. This contemplates that access to the property be on the property affected from the front lot line and be located 100 feet or more from side and rear property lines. Presumably, this restriction is in your regulations so that the trucks that will be part of the operation will not unduly affect and burden abutting property owners. This access restriction applies to truck access for all activities associated with the earth removal operations, whether it be for trucks bringing equipment needed for the excavation or blasting operations, trucks that will ultimately move the rock that is extracted from the site, or trucks that will bring soil onto the site to restore it after removal operations end. The access easement serving 42 Hallie Lane is not on any part of 40 Hallie Lane, and it's not even on any part of 42 Hallie Lane. It is entirely off-site. It therefore does not meet your requirements in the regulations that the access originate on the front property line and stay 100 feet from the property side and rear lot lines. Again, it's entirely off-site, and as such, the impacts of these trucks associated with this operation will fall entirely upon neighboring properties. Here, the truck access that the applicant has been primarily using for the past 3 years is not on the property. It's immediately adjacent to my client's property, and the frequent truck activity along that access drive, which is clearly and solely associated with the earth removal operations, has significantly impacted my client's use and enjoyment of their property and constitutes a significant nuisance to them, as well as other property owners who abut the access drive. The site plan, in my opinion, is deficient or non-compliant in all of these ways. Too much information is missing as regards to operations exclusively on 40 Hallie Lane, which is what is before you tonight. You need to make provisions to cover what happens if the many contingencies that the applicant's proposal relies on, such as the lot line adjustment, the zone change, and the ultimate special permit for 42 Hallie Lane, never come to pass. In addition to these deficiencies, there are a number of criteria for approval that must be met and are questionable at best. Section 214-70 C of your regulations clearly provides that no permit shall be issued unless the activity is found to not result in a condition which would impair the use of neighboring property and is found not to create a nuisance. Section 214-71A clearly states that blasting will not be permitted unless it is shown that it will not cause a nuisance or damage to nearby property. Section 214-102E requires this commission to consider the following criteria when evaluating and deciding upon a special use permit: the intensity of the proposed use and the impact of such use on neighboring properties, the potential for creation of a nuisance to neighboring properties, and the compatibility of a proposed use with nearby properties and the impact on the enjoyment, usefulness, and value of nearby property. For almost 3 years now, my client's use and enjoyment of their own property has been significantly impaired. They and their children are woken up in the morning by trucks lumbering along the access drive adjacent to their property. They are startled and disturbed each and every time the blasting occurs and shakes the house through. Their enjoyment of their property is significantly affected when they are in their backyard trying to use the pool or sit by the fire pit or cook out, and all they hear is jackhammering or blasting or truck backup signals and equipment and material being moved on the Eastman's property. One might expect to endure this type of brief annoyance from time to time in connection with short-term construction projects that homeowners might sometimes engage in. But this has been going on by the applicant's own admission for 3 years now. My clients no longer feel they are living in a residential neighborhood. At this point, they feel like they're living right next to a commercial rock quarry. Based on their experience, as well as the experiences you've heard from the other neighbors tonight, can you as a commission really make the requisite findings that the proposed use, the earth removal operation that's proposed and is happening and has been happening for quite some time, will not constitute a nuisance and will not impair the use of the neighboring properties? We say enough is enough. Section 214-71H of your regulations also say that failure by the applicant to meet any requirement applicable to earth removal shall bar the issuance of a permit. Well, first and foremost, your regulations require a special permit to do any earth excavation. And we all know that the applicant has failed to comply with that requirement for years. And on those grounds alone, this commission may be within its right to deny the current application. We feel it's time for this commission to follow through on enforcing its regulations, and I would submit that the application does not meet the regulations, and as such you cannot approve it. However, if you are at all inclined to consider approval, we implore you, based on everything you heard both from me and the other speakers in opposition tonight, to place meaningful conditions on any such approval. In your regulations in section 214-102F authorize you to place whatever conditions you deem necessary to assure that the rights and conveniences of local residents will be protected. If you are going to consider approving this application, please consider prohibiting the use of the access drive located within the easement that runs along 42 Haley Lane, as that is clearly not permitted to be used under your regulations anyway, since it's off-site. Please consider limiting the days of operations. Perhaps consider no weekend activities. Please consider limiting the hours of operation to 9 to 3. I think I heard some consensus in some of the comments this evening. Limit the overall duration of this permit so my client and other affected neighbors are assured that there is finally an end date in sight. You need to require a bond to ensure that the applicant complies with the conditions of any permit you choose to grant, and that the town staff can make necessary inspections to verify compliance. And for goodness sake, please keep your town attorney close by so that if the applicant continues to thumb his nose at the process, as he's done for the last 3 years, the town is ready to immediately proceed with a pending injunction action so that at least the rest of the nearby residents can have some peace and enjoyment of their properties. Again, we submit that this application is non-compliant and should not be approved at this time, but we ask you to consider those recommendations and conditions of approval if you see fit to grant it. Thank you.
Thank you.
Is there anyone else? Anyone else who would like to speak?
Good evening, Tom Clark from 175 Mountain Road. I just want to expand, can everyone hear me okay?
Yes, we can hear you, Tom.
Thank you. I just want to expand upon a couple of things, and I'm not prepared. I mean, obviously Dory, our attorney, came up and spoke very eloquently on this whole thing, and I just wanted to expand on a couple of things in regards to the trucking. Initially they were looking at talking about, I think it was 12,000 cubic yards a couple of years back, removing some of that, the rock outcrop, and expanded from 12,000 cubic yards to 19,000 cubic yards, and now it's back down to, I think, 9,650, correct me if I'm wrong. If they're putting soil up there, I talked to Dan, and Dan and I have talked back and forth a couple times. They're talking about putting soil up there and trucking soil up. In order to do that, I was trying to figure out how many trucks it would take. I've reached out to Tilcon, a couple of trucking companies that are local, because I'm trying to get a better idea and be educated as to how many trucks that would take. They indicated that typically a triaxle, which is one of the larger dump trucks, they usually hold somewhere between 18 and 22 cubic yards. So using a mean of 20 cubic yards, if in fact I think the new proposal is 2,500 cubic yards of topsoil, if you factor that in using 20 cubic yards and divide that by the 2,500, you're talking about 125 trucks being trucked up Mountain Road and being trucked up the access road next to our house. Now, for years, and it's beyond the 3 years, it goes back on and off to about 5 years, we've endured excavators, we've endured jackhammering, and it was about, and it's been surveyed twice, it's about 38 feet from our property line and about 80 to 90 feet from our master bedroom and our daughter's bedroom above us. The houses, and I've testified before in public hearings where we've had pictures falling off the wall. I mean, we've endured several years of this. I mean, we talk about being reasonable and prudent. If you look at Dwight or John, who are their attorneys, I can assure you, if they were in our position, they would be fighting this vehemently. It's about being reasonable. It's about abiding by the current regulations that we're all supposed to abide by, not just a select few. If, in fact, they decided to use the 9,650 cubic yards, if they have to truck that type of topsoil up there, you're looking at about 500 trucks. And again, you can factor this in. I've talked to several trucking firms. I've even talked to an engineer about this just to make sure my numbers were correct. And they've all concurred with me and indicated they were. I mean, this is a significant amount of trucking up Mountain Road, not just adversely affecting us. We're talking about affecting all the neighbors along Mountain Road. I think 2 to 3 years ago, the town paved Mountain Road recently. Well, about 2 to 3 years ago. I don't know if, and again, I'm not an engineer by no means, folks, but I don't know if, the road can take something like that. I mean, you were talking about a significant amount of truck traffic. I want everyone to take into consideration of that, because I think it's really significant here. In the final analysis, much like our attorney indicated, they were talking about, in the proposal, utilizing the driveway, his driveway, or the access road. I can assure you it's not going to be his driveway. I've spoken to him about that. It's not going to happen. It's going to be our road, or the access road next to us. And so you have the Welches, who actually have the stone house that's very close to the road, and you have a majority of us that are on that road that are gonna have to endure this. I ask and I plead with you, because we've been enduring this for the last 5 years, to really analyze this before you make a decision. And again, if it is a decision that has to be made, that you actually curtail the hours and you make significant conditions that are enforceable. Because what we found in the past is, actions speak louder than words, and that's, I've always used that phrase growing up. The actions here have spoken louder than words. Again, cease and desist have been violated. ZBA unanimously voted against them, and the work continued. I urge you to really analyze this, and if you do make a decision that's going to be feasible for the rest of us who have actually endured this for many, many years. Thank you for your time. I appreciate it.
Thank you.
Is there anyone else?
Yes, hello, can you hear me?
Yes.
Hi, this is Brian Dupere from 100 Long Hill Drive in Summers. My comments on this are a few. First of all of the houses in our neighborhood came with deed restrictions. This was a planned neighborhood development, and I just urge the town to make sure that any plans that are put forth or any joining of land that occurs with the easement property don't alter those deed restrictions. So we don't want farms in the neighborhood, no cows, no sheep, no pigs, no chickens, greenhouses, that type of thing, all not allowed in our neighborhood. It should be a pretty straightforward analysis. And as far as the noise, yeah, it's been crazy. It's been a long time. I'd even say more than 5 years, but certainly 5 years, and it's nonstop. I'm all for people doing, what they can with their property, landscaping projects by all means. This is not a landscaping project. There's less noise in, construction of highways than what goes on back there. It's just incredible, and if anyone hasn't seen it, I urge them to see it. And again, I understand what they want to do. They want to convert a home that's in a planned development into a home that has a farm attached to the back, that's great, but this isn't the type of neighborhood that that type of property was contemplated, right? So it changes the property values, it changes the feel of our neighborhood, and it impacts all the landowners in what I guess is Mountain Ridge Estates. I think that's the name of the development. So that's it.
Thank you, Brian. Is there anybody else that would like, this is Jill Conklin for the record, anybody else that would like to speak this evening? No?
Jill?
Yeah.
For the record, Carl Landolina. I can't see if anyone's coming up.
No.
All the public has already spoken?
Yes.
Everyone's spoken
Correct.
that wanted to?
Yes.
I believe everybody has spoken that wanted to. Jen, can you verify that there?
Yes.
Okay.
All right, again, Carl Landolina. I want to make some comments to sort of put this into context for the commission. You've had a lot of information given to you tonight, sort of about the history, but what I'd like to give you is the history that I'm aware of, because I don't live in town. So I can only tell you from my perspective what has transpired in terms of the legal process. So in September of 2019, going on memory here, the zoning enforcement officer issued a series of cease and desist orders to the applicant and to stop doing what we deem to be excavation work without a permit under your section of the regulations. That, there was negotiations, with the applicant following the issuance of that cease and desist, and we were under the impression that an application was going to be forthcoming. That application for a special permit was filed, and I think this was the second application that had been filed with your commission seeking a special permit for similar activities up at 40 and 42 Alley Lane. That application was subsequently withdrawn by the applicant. Jen, you can correct me if I'm wrong, February or March 2020?
Correct.
So after speaking with the zoning enforcement officer, I had advised the zoning enforcement officer to issue another set of cease and desist orders. And those are the ones issued in April of this year. While this was all going on, we were attempting to get eyes on the property by getting the town engineer perhaps and the zoning enforcement officer up to take a look around. You just can't enter a piece of property that's owned by an individual or a company. You can't own, town officials have no right essentially to enter absent exigent circumstances or some kind of criminal activity, or even then without a search warrant. And there's a civil search warrant process that the Supreme Court has outlined here in Connecticut, and we were not allowed on the property. So the first injunction action that you've heard of tonight, people have been referencing two series or sets of injunction actions. The first one had nothing to do with the activity itself. The first one was mainly or specifically an injunction action against the property owner, wherein we sought a court order to go up there and take a look around. That was the sole purpose of that injunction action. We filed that. Subsequently, we had conversations with the applicant's attorneys, and they agreed to let us go out and take a look around. And Mr. Board and Jennifer Roy did go up and take a look around, and I believe we then withdrew that injunction action because the purpose of our injunction action had been granted us voluntarily by the applicant, so we went up and took a look around. And I believe that was before the April cease and desist order. Following that April cease and desist order, the applicant, as was entitled to under the law, as you know, to seek a hearing before the Zoning Board of Appeals to make an argument before them that they were not violating the zoning regulations, that the activity which we had ordered them to cease and desist was not subject to a special permit under the regulations. And in addition, if the Zoning Board of Appeals was to find that the activity was subject to a special use process under the regulations, that they would get, they then at the same time, which is permitted under the statutes, they sought two variances to allow the activity to be undertaken without the need for a special permit. The Zoning Board of Appeals, in 4 separate votes, ruled against the applicant, both by upholding the issuance of the cease and desist for 40 and 42 Alley Lane, and denying a variance for 40 and separately 42 Alley Lane for the property, as was the applicant's right following the decision by the Zoning Board of Appeals. They have taken an appeal, and that appeal of the decision of the Zoning Board of Appeals is now pending before the Tolland Superior Court. As I stated, we did also file an injunctive action sometime in April, asking for something that's pretty rare these days, which is a sort of an emergency, what we call it an ex parte order of the court, asking the court to order the easements to stop activity, given that it was related to the removal of material from a piece of property excavation without a permit. That took a while, given the status the courts were closed essentially from early in March to, essentially they're still really not open at this point. And the court did grant us a short ex parte order, which ordered the easements to stop, and they did cease all activity. Sort of simultaneously with that, the court scheduled a full hearing to determine whether or not the ex parte order was going to remain in effect or be lifted. That ex parte hearing was scheduled for the day after the ZBA hearing was supposed to take place, which I expected would be pretty good timing, because if the ZBA granted the relief sought by the applicants, either by lifting the cease and desist or granting them variances, it would make the need for the injunction to be moved. And the town would not have to expend any resources arguing a case that the ZBA had basically taken out of their hands. The day before, the Friday of that week prior, the court informed us that the hearing was going to take place the following Monday, which did not give us, I would say, adequate time to prepare adequately for that hearing. And for other reasons I shouldn't go into, essentially, we decided that we wouldn't proceed on that particular day, on Monday, and that the hearing would either be Wednesday or sometime thereafter, whenever they could fit us in. The ZBA did what they did. The appeal was taken from that by the applicant, and we have been unable at this time to get another hearing in front of the Superior Court. During that time, we've been discussing with the applicant possible resolutions to the case. One dealt with a possible settlement by the Zoning Board of Appeals, which you've heard was turned down by the Zoning Board of Appeals. I won't go into the details of that because that occurred in executive session. But the goal, I think, of this office, based upon discussions with the Zoning Enforcement Officer, who is your enforcement arm, was twofold. One, to get the activity to stop, and two, to get the applicant or the property owner to come before you seeking permits, which we believe are necessary under the circumstances. So the activity has stopped. It hasn't been going on for, I'm not sure the exact date it stopped. It's probably been close to a month. And they have come before you with a application for 40, which, as you've heard tonight, is supposed to be dealing with only 40. I know there are other components that are going to be dealt with in other applications, but the application for you tonight is solely for 40. Now, I give you that information as context only. The fact that, in our opinion, my opinion and the Zoning Enforcement Officer's opinion, they've been violating the terms of the regulations for some period of time. I'm not sure how relevant that is in your consideration of this particular application, given that it was, our concerns with the activity was twofold. Again, that it was happening without a permit, and that the process was being overlooked by the applicant, and that they really needed to come in and get this before you in a proper way, in a public hearing setting, which is occurring tonight. So that's what we've been striving for the entire time that I've been involved in this matter. And the two things that we've asked for you've been given. Now, as to whether or not you're going to grant the application, that's entirely up to you. I never interfere in that part of the process. That's solely within your jurisdiction. I will say that special permits are, if you look at the case law that's developed around special permits are uses which are expressly permitted in the zone for which they apply, subject to a public hearing. And if there are concerns raised during that public hearing, either by the evidence, any of the evidence before you, that give you pause, your first goal, your first obligation is to determine whether or not there are any conditions of approval which will alleviate those concerns which have been raised before you. And if you can place conditions on the approval of a permit that alleviate all of your concerns, it's not like a subdivision where you're duty bound to check off all the boxes to give them an approval. But if you can, rather than deny a permit, if you can first alleviate all the concerns with conditions, then the law says that's what you should be doing. And only if you cannot alleviate the concerns with conditions are you legally justified in denying an application. Now, whether there are conditions of approval for this particular application, given the information that's in front of you, that are appropriate, again, that's between you, and that's for this board to decide. If you wanted help trying to draft something like that, staff, including myself, would certainly be able to do that. You've heard, some of the folks suggest conditions that would be appropriate. But again, it's your decision to determine, A, do you have a complete application in front of you? Are there, and if not, what other information do you need? And ask the applicant to provide it. If you believe you have enough information to make a decision based upon the information that's in front of you, then you could make a decision tonight and approve the application or deny it if you feel there are no basis upon which you can approve it, with substantial conditions to alleviate those concerns addressed or expressed to you this evening. So that's pretty much what I can explain to you about the process that we've been going through in our office to try to get what we believe the activity stopped and the applicant to come before you and give you the opportunity to have a hearing, hear the evidence from the applicant, and to hear testimony from concerned residents. So I'll be glad to answer any questions that you may have.
This is Jill Conklin for the record. Carl, did you have an opportunity to talk to the homeowner's attorney who spoke? The woman, I don't recall her name tonight.
Dory.
Dory Famigletti. Yes, I did. I had a brief conversation with her a few days ago. She was just alerting me to the fact that essentially she was coming, expressed some of her concerns. Obviously she had just been engaged, so I wouldn't have expected at that time that she would have made, let's say, a presentation to me like she made to you tonight. And obviously she's become more familiar with the application, the history, and all of that. So I didn't hear her full presentation on the phone a few days ago, and I wouldn't have expected to.
Okay.
For the record, Carl Wallen, I have a question, but I don't know if it's better directed at Attorney Landolina or at the applicant. I believe that Dory, when she was speaking about the application and the attached map, indicated that what we're looking at is not actually a reflection of what constitute 40 and 42 before any changes are made. And I guess my question is that true?
Well, for Carl Landolina, for the record, I have not gone over the map in any detail, so I really couldn't answer that question. I will say that the process to do a lot line reconfiguration here in Somers is different than it is in almost every other town in Connecticut. There are a number of cases, and this has just been
Carl Walton,
reaffirmed.
if I could just interject.
Go ahead.
Well, my concern is that we've been given information that's inaccurate as the way it was represented as to what portions of the crosshatch line on the plan that the applicant spoke about is part of 40 or 42.
Well, I have, Carl Andolina for the record. I can't speak to that.
I mean, Bill Conklin for the record, is Jay Earthman still there? Because he could probably address this.
He is.
If he wants to address this.
For the record, Jay Ersfree with J.R. Russo and Associates. And I think some of the confusion might rest in the fact that all of these applications and all of the supporting materials and documentation are all on the town's website. So when you go there and you start looking at this, it's a little difficult, maybe a little confusing to determine which map or which exhibit goes with which application. But let me just clarify now, in terms of the application that you're considering this evening for 40 Halley.
Carl Walton for the record, Jay, if I could interject.
Yes, go ahead.
I asked you earlier about a specific site plan, if that was the one you were describing.
Correct.
And you said, yes, it's one that says site plan on it, dated 7/20/2020.
Correct.
For a job number 2019-060, sheet 1. My question is, does that plan accurately reflect 40 and 42 as they are prior to any changes in the property lines?
Yes. It only shows activity and proposed grading on number 40 Halley Lane, which is the crosshatched area.
So the property line meets up perfectly like it does on your map here?
That's correct. The property line and zone line are coincident. They're one and the same.
Thank you. That answers my question.
Thank you, Jay.
For the record, Carl Andolina, does anyone have any other questions or comments from me? Dan, I think you need to unmute yourself.
I have a question, Carl. Jill Conklin for the record. Is there any type of pre-survey that's done to surrounding structures prior to blasting, or is that something someone must request? Because I'm just curious about that as to, like, one gentleman said he had a broken window. Somebody else said they have pictures falling off the wall in their houses. I mean, does somebody go around, insurance person that works for the company that does the blasting, do they go around and do a survey to check out, like, okay, does this foundation have a crack? Where's, do they do that in the neighborhood, or I don't really know all that much about blasting, to be honest.
So Carl Andolina for the record, and I'm sure that the applicant's counsels can fill in the gaps here, but there is something called a pre-blast survey, and I guess it's sort of, I'm sure there are different components to a pre-blast survey. I would think some of the components in properties where there is well water would be tested beforehand. The foundation of the structure, any structures would be looked at to see what condition they're in. I suppose you could order other things as well. Those I would think would be the two main components.
Do we know if that has been done?
For the record, Carl Andolina, I do not know if that's been done on any of the, I think that some of these folks have had, at their own costs, some surveys done. I don't, how far they go back, I couldn't tell you. you know, we've had evidence that the blasting has been occurring for some time, you know, but, you know, certainly that could be a condition of approval, that the pre-blast surveys would be done on properties within X amount of feet. I suppose that'd be up to you. I'm not an expert to determine how far out it should go. I assume the report from Steve Jacobs of the memo deals with that issue, or the report from the engineering firm in terms of what radius from the blast area would be an appropriate radii for pre-blast survey.
Yeah, Jill Conklin for the record. I just wonder if there's a third person that can give us some insight onto blasting and what we need to know. Frankly, I don't feel like I know enough. I mean, I'm hearing about, you know, people and their issues with the noise and the wells, and yeah, I'm just curious what's out there for us to tap into that's not associated with the company that's up there doing the work, a third person.
Yeah, for the record, Carl Andolina, I mean, there's an expert for any kind of field that you can possibly imagine, so I'm sure there is somebody that could be engaged to answer those kinds of questions for you. You know, Steve Jacobs deals only with the septic and well issue, so, you know, he wouldn't, to me, I don't think he'd be guessing about what an appropriate radius would be from a blast site when it comes to structural issues in houses. So, you know, the other thing I would say is that, correct me if I'm wrong here, because sometimes I get my towns mixed up. I believe you have an ordinance in which you could, Jen's shaking her head yes or nodding, so you do have an ordinance which would allow you to seek out that advice and counsel and ask the applicant to pay for it. You could hire an independent, as I say, person and ask the applicant to pay the cost of that. It would seem to me that there is either in deep rules, you know, Department of Energy and Environmental Protection, because, you know, the state of Connecticut does get involved in blasting permits as well. It's not just a local decision. They may have that information. I know that one of the neighbors did mention some regulations from DEEP. I'm not familiar. I know that there are blasting regulations. I don't know the answer to your questions or not. So you could start there, I suppose, or hire an expert. The other thing I would say is that the excavation section and the blasting section, although they're sort of contiguous in the regulations, are really two different sections, and that you can allow an excavation permit without giving someone a blasting permit. So that if you felt that the application was worthy of a permit for excavation, but that blasting should not be allowed given the proximity to residential structures or whatever, that's entirely up to you. Whether you grant somebody a blasting permit would be separate and apart from it. There obviously are other ways to remove this rock, and you've heard that there was a jackhammer up there, and that was removing some of the rock. There was also the hydraulic process being used, which is, I guess, still going to be used up there. And I think Mr. Merriam, or Jay Ussery testified that, if they didn't testify to this, I apologize, it should not be taken as evidence then. That the fissuring process is hydraulic fissuring, which Jen and I did witness, going to be used in some of the areas near the house. And maybe the applicant's counsel or engineer can confirm that. So, and I don't, again, I was up there, I just happened to go up there a day when they were involved in that process, and so was Jen, and so I'd rather that she gave you her impressions rather than I give you my impressions of what she heard and saw, you know, on the site. And we did travel around the neighborhood and tried to stop at some of the houses of some of the folks that spoke tonight. I'd rather she gave you that information rather than it come from me. But, so, you know, there's that component as well. You've got an applicant asking to excavate the rock, which is permitted under the regulations by special permit, subject to conditions that can impose upon them to alleviate concerns. And then you've got this request for blasting as well. They're part and parcel of the same application, but it's not necessary for you to grant both of them. If you thought that one was appropriate and the other was not, that'd be entirely up to you. Or you could seek out more information on the blasting component.
Jill Conklin, for the record, I don't know, I think I've been on this board for like 15 years, and this is only the second time I can recall dealing with blasting. The other time was up on La Cabana, and we never really heard from anybody. It was very quiet. I don't know how quiet it was there, but I mean, the board, we didn't have any complaints there, and this just seems to be a much bigger endeavor.
Carl, Dan Farrell, I have a question for you. Like if they're going on the gravel bank rules and regulations, we would be setting the bond on that area, on the damage to wells or the damage of foundations and stuff like that.
So, Carl Andolina, for the record, I read the regulations to require the bond. Well, first of all, you have erosion and sedimentation control bond, which is, you know, typical in every project. So that'd be one type of bond. And the other bond would be for the restoration of the site, to try to predict the cost of repairing someone's foundation or ridding a well of you know, radium or radon or other, you know, constituents of concern. That's not something I would advise you to get into. You know, because then we're getting into the middle of a dispute between what I would think are two private landowners, and I would not suggest that you take that tack. And if you were, if that was a concern of yours, I think it should be dealt with in other ways other than trying to get $100,000 bond from the applicant to make sure that if anyone has a crack in their foundation, it's going to get fixed. I don't see the town wanting to get in the middle of that kind of thing. The other thing I point out, I made some notes while people were talking. Someone had brought up deed restrictions. So deed restrictions are, you know, matters of title. And zoning boards do not get involved in title issues. So if there is a deed restriction that somebody is believed is being violated, that's again between the homeowners that are subject to the deed restriction and the alleged violator. You know, I don't know anything about these particular deed restrictions. It's not unusual for there to be language in there giving either an association or the group of homeowners that are subject to them rights to get a recalcitrant property owner into line in terms of restrictions, but they're really of no concern of ours, so it's not something that I would suggest that you get into.
Thank you, Carl.
Jill Conklin, for the record. So, you know, now it's 10 minutes after 9. I'm wondering if the applicant is going to want to speak at this point.
Before we go to rebuttal,
Attorney Famigletti would like to speak again.
Yes, I I'm sorry, I won't reiterate anything I said. I just had one more question, again, to Dory Famigletti for the record. Maybe perhaps some of the confusion may have been because the plan that is being presented from tonight is not any of the plans that was posted on the town's website. I'm looking at this, and this is not one plan that was on the town's website. It perhaps would have been helpful to have. And it does answer a couple of my questions with regard to the specific area of material to be removed solely on 40 Hallie Lane. But this, again, was not posted on the town's website. I should also add, nor was the report that's been referred to this evening from O'Reilly, Cabot, and Oakland, or the January 2020 memo from Steve Jacobs. None of that is information I had an opportunity to review before my presentation this evening, and that's all new information to me. I would ask you to consider that, and also consider the executive order that requires this information to have been posted prior to, which it was not. Thank you.
Thank you.
Jill or Jennifer Roy for the record, and or Carl Landolina. The documents that were presented tonight are exhibits as people would normally present at a public hearing, so I'm not sure how that lies with the executive orders. That's why they're exhibits.
Well, except the map today.
The map I would need to look into that.
Yeah, the map definitely contains different information. That was Dory Famigletti for the record.
If I might, Carl Landolina, I'm not in the room, obviously, so Dory, that's not in Executive Order 7I, the one that covers most of these things. And I seem to recall, as I mentioned earlier, a couple of hours ago, that I thought there was some language in the subsequent order dealing with this. Can you share that with me? Do you know
I'm not aware of
which order
anything,
that is?
Carl, subsequent to 7I, but 7B, which is the FOIA relaxation.
Oh, right. Yep.
7B talks about posting materials prior to on the website. And certainly for the applicant to present a plan tonight that has different information than what was posted on the website, I think doesn't allow the public a fair opportunity to review and be apprised of what's happening and present competently.
Carl Walton for the record. In fact, the map that I was asking about, which I was referring to as the one that Jay Ursary was presenting from, is on the website. It's listed as Site Plan 2.
There's a set of maps on the website that are a set of 3 series, sheets 1 of 3, 2 of 3, 3 of 3. That's what was filed on the website. Those were the ones I was referring to. There is also the zone change map posted there, and there's a lot line adjustment map posted there. There's also the original one-page site plan that accompanied the original application, but the revised plan superseded that. And even the original one-page site plan that accompanied the original application is not the same as this one.
Carl Landolina for the record. So, Attorney Famigletti is correct. So 7B, which obviously predated 7I, requires the following, and this was to make up for the fact that essentially the governor was suspending open meeting requirements of the Freedom of Information Act. And the relevant section is Section 1 of 7B. In subsection 4, requires that any materials relevant to matters on the agenda, including but not limited to materials relating to specific applications, if applicable, shall be submitted to the agency a minimum of 24 hours prior and posted to the agency's website for public inspection prior to, during, and after the meeting. And any exhibits to be submitted by members of the public shall be, to the extent feasible, also submitted to the agency a minimum of 24 hours prior to the meeting and posted on the agency's website for public inspection prior to, during, and after the meeting. So that's the requirement.
Walton, for the record, I don't really have any more to say on the map concern, because the map that I have attached to tonight's special use application, which I believe is the one that Jay Ussery spoke about, is available on the website and has been for a couple of days.
Yeah.
I'm looking, Carl.
Jill Conklin, for the record, because that's marked map 1 of 1, it's the only map for this application, correct?
Correct.
Okay, so the other maps that the attorney's referring to are maps that are on the website for other applications.
Correct. They're actually on the agenda tonight to be received.
Okay, so that's a separate application that we're receiving.
For the record, Carl Angelini, I believe there are two separate applications. One for a zone change and one for a special use permit, should the zone change be granted.
Okay, on our website, and I'm not sure if it's the one that is linked to the zoning page, but the application for number 20-009 is 5-page PDF. And that map is page 5. So it's not specifically...
That's the original one. The page 5, original one?
It was.
Let me grab my copy.
This is Dwight Merriam speaking. Jay Ussery and I were just having a conversation aside here, and maybe he can answer in part the question. He delivered a map to the office. But I think what's really critically important here in this difficult time of pandemic and changing rules in the landscape is that all of the substantive evidence presented this evening, both in oral testimony and in the plan that is here, is the same as the plan that was submitted and posted, and is all that is relevant to the decision-making criteria. So, regardless of the slight deviation that there may be that we're still wrestling with trying to determine, substantively they are the same.
Story, Samet for the record. There may be some consistencies and similarities between the maps, but they are not substantially the same, because the map that I'm looking at here does in fact quantify an area of material to be removed solely from 40 Haley Lane. The maps that are on your website do not, and the narrative on the website refers to the overall amount. So there are some differences here that we were not able to review ahead of time. And I don't know with a quick cursory look right now if that's the only difference, but be that as it may, this map, as required by the executive order, was required to be published on the website prior to, and it was not.
Carl Walton, for the record. So what would be a remedy for that?
Jill Conklin, for the record, I think a continuation, and give everybody time to see the maps that are in question. I mean, you guys are all there with, I mean, I'm not there. I can't see the maps. I don't know. I'm looking on my iPad from the emails I've received.
Right, Jill. Jennifer Roy, for the record. I've been working with, including today, I had Dwight send me separate emails with what map goes with what application, because Jay did get me the hard copies and PDFs, and they were uploaded, and in conversations with Attorney Famigletti and a couple of residents, tried to reorganize that web page under Zoning Commission to have them properly listed with the proper application number, corresponding application number. So, still, as of today, working on trying to get all the documents cleared up and labeled properly.
Jill Conklin, for the record, rightly so. This was kind of, it just seems like it came on pretty quick. I don't know how long you've had the maps, but I think we need to. If the applicant wants to say something else, or maybe somebody should make a motion and continue this. I don't know the feelings of the other members. If there's any more information that needs to be had.
Carl Walton, for the record, I'm not sure that we have everything we need without looking at all the things that were submitted into Town Hall. As I had spoken earlier, I received a group of emails with maps from various applications, and trying to view them all in PDF form made my head hurt.
Yeah. Jill Conklin, for the record, all those maps we're looking at are 8.5 by 11. They're just printed off my copier, and honestly, it's really hard to read.
Jennifer Roy, for the record. Jill, perhaps, you could request hard copies from the applicant.
Yeah, or, it's hard even to be, for me, it's hard to be here at my house on a Zoom.
Right.
With Jay Ursery describing something I can't even have my eyes on. It would have been nice if we could have had a shared screen, if they had the ability to have that on a computer and share the screen with us while they talk about it. So, for me,
or if packets were mailed to each of you.
Yeah, I know. I got the packets.
No, if not email, mail, hard copy.
Mail.
Mail you the map, the application and the map that goes with it.
It's still helpful to have somebody pointing like this.
Absolutely. Correct.
Yeah. Maybe I'm not the only one. Am I the only one that had trouble following that?
This is Paige Rassid. Absolutely not, Jill. And I know earlier on in the meeting you asked for hard copies of the maps. I think getting a package before the next meeting, clearing up the website to make it very clear which maps and pieces go with which application, I think will help people who are interested in this issue. But with all that said, I'd certainly be ready to make a motion to continue this public meeting.
Is that an official motion, Paige?
I'd like to this is Paige Rassid. I'd like to make a motion to continue this public meeting.
Hearing.
Public hearing.
I'll second that motion.
Paige
Madam
Rassid.
Chair?
Paige Rassid. Go ahead, Carl.
To interrupt for a second, Carl Landolina for the record. So, if you're going to continue the matter, I would suggest that as part of that process, you discussed whether or not you're going to engage the services of a consultant or give someone on staff, myself or Jen, or maybe even Jeff Ford, the task of determining what would be included in the pre-blast survey, what could be included, those kinds of things.
Yeah.
Carl Walton, for the record, I would only add that given that I believe there is some language in the requirement for blasting, that it's expected that they're going to need to provide a new pre-blast survey. Even though blasting has gone on already, we want to ensure that there's no further damage if there was in fact any previously.
Yeah, so part of Jill Conklin for the record. So Paige made a motion to continue. Carl seconded. So we'll have some discussion. And
excuse me, Madam Chair, this is Dwight Merriam.
Under discussion, we would also need to include when we would continue it to.
Jill?
Because that wasn't part of the motion.
Correct.
Is it appropriate time? Dwight Merriam would like to
I'd like to be heard on this before the commission proceeds. I only got to speak briefly.
Can you hear him, Jill?
Can I hear him?
Yes, this is Dwight Merriam.
Oh, yeah, I can hear him.
Briefly on the issue of the plans that were submitted and posted. Attorney Famiglietti spoke from, I lost count, but it looked like 10 pages, double-spaced, typewritten, and I didn't know she was retained until this afternoon, and she had not contacted me. I called her, which I wish that some of the things that she raised we had known in advance, because we could have addressed them before this evening, and we can address them point by point in a rebuttal if we get to that point. But I would stress that even though there may be a disconnect between what is posted on the website and what was submitted to the town for posting, the fact is, as I said briefly shortly ago, substantively the issue of 9,650 cubic yards, 1,500 or 1,600 yards of which would be hydraulically fractured and the balance would be blasted, where it goes on the site and the grading, all of that is the same between them. Substantively, they are substantially the same. And I consider this to be a minor Scribner's error in the difference between the two of them. We don't know what the difference is, but we do know that all of the testimony that you heard this evening is the same for any plan that the town has. And all of the testimony you heard is that which is relevant to your decision-making criteria. So I would strongly urge this commission not to continue this hearing, but to go ahead and close the hearing and vote on it this evening one way or the other, so we can determine whether we go forward on the 3 subsequent actions. Thank you.
Jill Conklin, for the record, I don't know if you want us to do that, because I feel like I need more information, and if I don't have the information I feel I need, it's probably not going to be favorable for your applicant, or your client. Am I the only one that, Jill Conklin for the record, am I the only one that feels like we need more information? I would like a pre-blast survey. I would like,
If I may, I'm going to interrupt for a second, Carl Andolina. I certainly within your right to continue the public hearing and ask for additional information if you feel it's appropriate. I would urge that no more of the commission give their opinion as to whether they would approve something in the current condition or not, just that you feel you need more information. Thank you.
Thank you, Carl.
so noted.
Paige, would you like to amend your motion to the date of continuation, like our September meeting, perhaps?
Jen, do you know that date?
September 1st.
September 1st,
It's Tuesday, September 1st.
So for the record, Paige Rassett, I'd like to make a motion to continue this public hearing until September 1st, our regular zoning commission meeting.
And do we want to add in anything to?
Yes, Carl Walton, for the record, I believe we would like to see before that meeting takes place, hard copies that clearly identify which application those plans are for, to look at any and all data that can be obtained as pre-blast surveys before we consider allowing more blasting. I'm not sure what else.
Let's see. And maybe look into the regulations from deep.
Carl Walton, for the record, also a reasonable bond estimate of what it might take to finish the job if something should happen, or along the lines of that, the normal bond amount, not one to cover for damage. That's not what we're here for. In other words, for a normal special use permit for a extraction or filling operation, you get a bond that's put in force so that the ground can be made stable, etc., as was spoken about earlier in the meeting. And I believe the amount should come from the town engineer as to what he feels in his ability is an adequate amount.
So there's a motion on the table for hard copies, data provided to us regarding pre-blasting,
And a bonding estimate.
bonding, and a bonding estimate from the town of Summers engineer. Paige, is that your motion?
So moved.
And continued on our next regular meeting on September 1st at 6:30. Hopefully, maybe at the town hall if I may go. And Carl, second that motion?
I will still second that motion.
All in favor of that motion? We'll start with
Paige?
Paige Rasted, aye.
Carl Walton, aye.
Dan Farrell, aye.
Jill Conklin, aye. That's a unanimous vote for continuation of this public hearing until September 1st. Look forward to seeing you then. So we're gonna, the time is 9:33.
Jill?
So we're gonna move on. We still have, a couple things on our agenda. So, old business, discussion possible decision of application 20009 Eastman, Amy Eastman, 40 Halley Lane, Summers, Connecticut, pursuant to Article 12, earth removal and filling, Section 214, 70, an issuance and renewal of a special use permit application, is seeking a special use permit to undertake excavation, removal, and filling of approximately 9,650 cubic yards and removal of that material to the abutting adjoining parcel at 42 Halley Lane.
Jill? Excuse me.
That's pursuant to the closing of the
Right,
public
so
hearing.
that is,
Pushed.
yeah, tabled.
Excuse me, Jill, can you pause for 1 second? Everyone's leaving, so that's okay. I just can't hear with all the commotion.
Okay.
I'm sure the recording is probably picking up all the commotion. All set, thank you.
Are we all set?
Yeah.
Okay, so I read in that first, application under old business, which is gonna be tabled because the public hearing is being continued. The second item under old business, possible discussion, is, the possibility of a farm winery regulation text. Now, I have,
I thought there were other applications.
but that's under new business.
Oh, okay.
And I think we'll do.
I think the conversation on farm wineries, we need to table again. I would just ask everybody, read it. We've already been here for 2.5 hours. I'm not sure it's gonna be even a remotely productive conversation at this point.
It's actually been 3 hours.
Right.
Okay?
Yeah.
Do you just want to confirm that everybody received it, Carl, and see if, can I just ask if anybody would like to?
Paige and Dan, did you both receive the information I sent out with the proposed regulation?
Yes.
Yes.
Okay, I was going to ask if you needed a hard copy of anything or all of it, or since I have you.
Can we, this is Dan Farrell, can we, have a special, meeting to move them along? They've been out there quite a bit, you know? Can you find that in your schedule, or not?
I'll be out of town from August 14th to the 22nd, actually out of the state, and I will need to quarantine when I get back. So the only way I could...
Okay.
So when you go away, Jen, you're gonna stay home, work from home for 2 weeks?
Right. So I would have to look into the fact if I can get to do the streaming from home. I can Zoom from home, but the streaming on YouTube so that the citizens can watch it, I just need to see if I can coordinate that. So, if you're thinking something after the 22nd, before September 1st, which is already looking like a big agenda, I can get back to you all.
Yeah, because, I mean, on Jill Conklin, for the record, on the 1st, we're gonna have the continuation of what we just heard.
Right.
Which will probably be lengthy again.
And potentially more, depending on how the rest of the evening goes on the agenda.
For the record, Paige Rasted, could we maybe schedule something then? Maybe the second Monday of September?
I think Dan, for the record, Jennifer, Dan was asking about doing something sooner for the winery rather than waiting till September 1st. Is that what you were saying, Dan?
Yeah, they've been out, you know, hanging out there for a long time, you know? And they want to get going on their project too.
Jill Conklin, for the record, Jennifer, do we have this, what we have in our hands tonight for the proposed winery, do we have that on our website, or is that not?
That's not part of a public hearing.
No, it's not a public hearing, but no.
So it's not on the website.
Okay.
And we're Paige Rasted, for the record, I don't think we're ready to even publish the draft as, you know, a beginning before we start to discuss where everyone is coming from with the wine regulation.
Jill Conklin, for the record, I'm wondering if maybe there's like just an hour we can carve out for just this, where it doesn't have to be, just some night, it could be even at 7 o'clock, where we can carve out just an hour for this winery. In Carl Walton, how do you feel about that?
I'm not opposed to that, Jill. It's just when.
Yeah,
I also am going to be leaving the state on the 15th of August, and not returning until the 23rd. And I'm also going to a state for vacation that I'm going to have to self-quarantine from when I return.
And so
I wonder if next week, if there's like a time that we could just, we'll say 1 hour, that's it. We're just going to discuss for 1 hour, and we come
propose a day.
How about, what is today? Oh, like I don't know, like Thursday the 13th.
No.
Okay, the 12th, Wednesday.
Sure. I could do Wednesday the 12th.
We could do Wednesday at like 7 o'clock.
I know that Jennifer won't be able to do Wednesday the 12th easily, though.
Why?
Why?
Or maybe she will.
I go away on the 14th.
Oh, I thought you were leaving on the 13th.
No, I'm leaving on the 14th, so I definitely would not want to do the 13th, but, and I'm assuming that, would you want it some other time than, 6:30?
I think I would want it. If I would want it a little later.
Oh.
Am I crazy saying that, or should we go earlier? I could go earlier. I could do it at 4:30.
Well, I have to see, I'm not sure, I have to see if there's a way that I can stream from home, or if I've got someone who could help stream, because Zoom is not the issue, it's the YouTube streaming on our website.
But if you record it, can't you upload it to the YouTube website?
I'd have to look into it.
It won't be live, but, it would be delayed.
It is recorded on Zoom. I don't know how to get that from the cloud, to get it on. There's not anything I'm not really prepared to answer tonight, so I guess you'd have to just try and schedule something at a time that you want. I definitely would probably not ask you to not do it later than 6:30, Jill, but...
I'm just...
Yeah.
I'm just thinking that, if we carve out 1 hour and just stick to this, and everybody knows it beforehand, they read it and come in with some ideas or comments onto what's been,
Carl Walton, for the record, I would encourage anybody to take what they received and mark it up any way you see fit. Put comments there for things that you don't like, change it or improve things you think would be improving. I mean, we're trying to come up with a regulation, not for any particular site, but for the town as a whole.
exactly.
So in my mind, we're not holding up anybody, because right now, there isn't a regulation for them to do any of it. But I'm willing to meet.
Yeah, Jill,
I mean, I think it's smart if we meet next week for an hour, because then we get a lot of this stuff out, and then we know where everyone's coming from, and then you guys go on vacation and have a wonderful trip.
visit wineries.
And then when we, reconvene, at least we'll know where everybody's coming from, and maybe even have a regulation before the end of the year, because we still have to set a public hearing, and
We do. And then we have to accept an application for the specific property that is going to apply.
yeah, so there's still quite a bit to do. I mean, and we're getting down. I mean, I hate to keep scheduling all these special meetings, but I'm saying 1 hour. I mean, I don't want it to be 2 hours and.
Pick a night. We know when to be there.
Does everybody work during the day? Okay.
No.
I do.
Then why'd you ask?
I'm curious, because I might take an hour in the middle of the day and work a little later. I might carve it out if it was helpful.
Oh, you mean like a lunch hour?
Yeah, like something like that.
Carl, can I ask you a question just one question on this? The Connecticut has a bunch of rules and regulations already in it, and they can operate on those regulations. Is that correct?
No.
It's not correct.
The regulations allow them to set up a winery, but they don't give them a permission to set it up in a town that doesn't allow them.
Right.
Yeah, we have, Jill Conklin, for the record, we have to have regulations for somebody to come into our town once they get their state
And federal license.
and federal, yeah.
Yeah, because I wouldn't say this in public, but I think they got their...
And you are in public.
Well, you're in public.
You are in
All right, never mind.
And it's perfectly okay, Dan. There was I don't know how to have this discussion legally. We can't have this discussion.
Why don't we just go and pick a date and time? Paige,
Paige, what works for you? Does the 12th work for you?
Monday or Tuesday would be best.
How about
anytime after 5:30?
So you don't have a lunch time that you would, no? I'm just asking.
Not dependably.
Okay.
Not that way.
Carl, how does Tuesday, the 11th, work?
Right now, Jill, I think it works fine.
Okay.
Why don't we aim for Tuesday, the 11th at, what'd you say, Paige, 5:30?
That would be fine. Anytime, 5:30 or after.
Yeah, we'll run from 5:30 to 6:30 and just see what we can, or shorter if need, if we don't need the time.
So do we need a motion to schedule?
Yep,
A special.
I'll make a motion to schedule a work session for the zoning commission on Tuesday, 8/11, beginning at, was it 5:30?
5:30.
I'll second that.
Only to run 1 hour.
We need to run 1 hour.
5:30 to 6:30.
Carl made a motion for a special meeting for a work session on 8/11/2020 at 5:30 via Zoom. Dan seconded it. All in favor? Aye.
Aye.
Aye. Okay, we'll see you then. Well, actually, we still have to go on to the rest of this.
I'm so tired, I was gonna say thank you, but I wrote it in my notes instead.
I'm like, done?
All right,
So, new business, to be received. We have two things under new business. Application 20-010, Amy Eastman, 40 Halley Lane, Somers, Connecticut, a zone change from residential A zone to a residential A1 zone for a portion of the conjoined parcel at 42 Halley Lane.
So, Jennifer Roy, for the record,
Anybody here, or did they all leave?
they've left. Everyone left.
Counsel for the applicant left?
Yes,
Oh.
everyone left, so there's no one here to speak on it.
Okay.
I can tell you that, so 20-010, they have an application into the Planning Commission for a lot reconfiguration, so it really, if you want to receive it and schedule a public hearing for September or October, I'm not, or how you want to handle this, and then same with, so 20-011 would be to get a special use permit for that section that's rezoned. So, they're not here to...
We have to accept the application tonight, or not? Do we have everything we need for this application, or not really, because they haven't done their lot reconfiguration with planning, right?
Right.
I mean, they're doing a lot reconfiguration with planning, but they want to do a zone change here.
And I don't know what's going to go on with the executive orders as far as timing and having, the 90-day extension on things.
So do we have everything we need for this application?
Well, I believe that we have all of the supporting documents and maps. I have them here. I have the original hard copy, and Jay did email me everything in the PDF. I think it's just a matter of clearing up what went on the website. Well, they're all on the website, it's just a matter of what went under the zoning commission page. So we do have the documents.
Okay.
And I would be inclined to send you hard copy packets of those as well.
All right. So do we have a motion to accept this application? I don't think I see Carl on here
He
anymore.
just texted me, he got, his internet dumped him.
Okay. Lucky Carl. No. I wish my internet would dump me.
Well, you know what, I can call him, I don't know if that'll work, and put him on speaker. So.
Can't believe that. So, does anybody want to make a motion to accept this application?
So, for the record, Paige Rasted, I'll make a motion to accept the application, number 20-010.
Now,
Oh, okay. Carl's here.
Wouldn't we normally be referring this to planning?
Correct.
And refer it to planning.
Yep.
I know they're already in planning, you said, right?
No, they have a lot line reconfiguration application in.
At planning.
Right. So that'll be next week's planning meeting. So this would also then go on the same agenda.
Okay.
I'll second that.
So Paige made a motion to refer this to planning, but we also have to set a public hearing, don't we?
I don't think we have to right now.
I think we do.
Yeah, I think we do. For a zone change?
Well,
Yeah, well, I mean, you can receive it, you can schedule it for October. But planning will be, planning, we'll hear about it next week.
Can we just receive it and not schedule a public hearing?
I don't, Carl Wong for the record, since I got dumped by my internet and I really don't even know what you're discussing.
Okay, we're discussing number 1 under new business, application 20-010, about the zone change for Eastman's at 40 Halley Lane. And what
Until they redo the lot line, how could we have a discussion on something that doesn't exist?
So maybe, Jill Conklin for the record, that's what I was asking, do we have everything we need? I don't believe we have everything we need, so maybe we wouldn't accept this application at this time.
That would be my opinion.
Well, somebody can make a motion.
Well, no, you can just you can vote on the motion you have, it would just be about who's in favor of it passing.
Well, the motion we have never got second,
Dan seconded it.
did he?
And I'll withdraw my motion.
I did.
Okay, so discussion.
Way to go, Paige.
And
I'm gonna say the discussion is, we don't have everything we need for this application.
okay,
And like Carl Walton said, they're still in, Jennifer said they're in planning, and they're doing a lot reconfiguration there, so until they get that,
right.
it's premature. So, let's vote on that motion if nobody else has any discussion.
So it's either in favor, yes, or
Yes, in
opposed, opposed.
Or opposed, right. So all those in favor, aye.
In favor of,
Wait,
But
Jill, are you in favor of accepting and referring
No,
to
I'm
planning?
not.
So,
I said no.
whoever's in favor, well, you said aye. It's like you were voting.
Well, I'm tired.
I know,
Who's in favor of accepting the application? Is that what you wanted?
correct.
Yeah. Who's opposed as accepting the application?
aye.
Aye. Aye.
There you go.
Dan's undecided.
Dan?
Aye.
You're opposed.
Okay, so.
Motion fails.
We're not accepting it. That's unanimous. We're not accepting that application. We're gonna move on to the next one. Application 20-011, Amy Eastman, 40 Halley Lane, Somers, Connecticut, pursuant to Article 12, earth removal and filling, Section 21470, issuance and renewal of a special use permit application, is seeking a special use permit to undertake excavation, removal, and filling of approximately 9,650 cubic yards and removal of that material to the abutting joining parcel at 42 Halley Lane.
It's not a practice that's allowed on 42 Halley Lane because 42 Halley Lane is a zone.
Right.
Correct. So.
Motion to reject.
Carl Walton to help me with.
Motion to reject.
I make a motion to not accept that application as well.
Carl made a motion to not accept the application.
I'll second that.
Any discussion? All in favor of not accepting the application? Aye.
Aye.
Aye. Carl's muted.
Dan Farrow, aye.
Aye. Carl Walton, we didn't hear you. You were muted.
I have two mute buttons, so I unmuted that and muted my microphone. Aye.
Aye. Okay, that's unanimous. The application is being rejected. Okay, so.
Is there anything else on the agenda?
There's an adjournment on our agenda.
We'll make a motion to adjourn.
Thanks, Dan.
Oh, let's stay.
So, you know what, it's 9:54. Dan made a motion.
second.
Hello? Motion. Hello?
Hello?
Yes.
Hi, I'm sorry, this is Kathy Welch. I've been following the meeting since 6:30 this morning. And my notes indicate, and maybe I took it down wrong, was that everything was going to be continued on Monday, September 1. Is that right?
We're continuing, this is Jill Conklin for the record, we're continuing the public hearing.
Yeah.
Until September 1st.
Okay, that's a Tuesday.
Yes, that's our next scheduled meeting.
Okay, I'm sorry, I misunderstood. I thought it was Monday, and I was going to help you not to have to re-scurry, that's all. Sorry.
Oh, no, thank you, Kathy.
No,
you betcha, bye-bye.
All right, bye-bye. So Dan made a motion to adjourn at 9:55. Does anybody second it? Paige seconded it. Any discussion? No. All in favor?
Let's stay.
Let's stay. No, let's not. Let's say good night. All in favor of the motion for adjourning at 9:55? Aye.
Aye.
Aye. Aye. Aye. Okay, motion carries. Sorry, guys, I got a little crazy. Tired.